Next we begin Session C. C covers page 56 to 75 in your textbook. So let's look at Chapter 3, page 56. At the top of the page, that first paragraph talks about the fact that instead of being called real estate agents, we should really be called real property agents. And the reason why is that we include the bundle of legal rights in the definition of real property. Taking a look at number 1 to 5 at the top of the page, the rights of ownership include the right to possess, the right to control, the right to legally enjoy the real estate. Number 4, the right to restrict individuals from entering or occupying the real estate, and the right to dispose or sell the real estate. So these are all part of the bundle of legal rights that we'll talk about a little further down on the page as well. In the middle of page 56, top middle part, we look at other ownership rights that include the rights to devise the real estate. So when we talk about devise, we're talking about the ability to leave by will real estate to various individuals. Mortgage and encumber the real estate is another ownership interest. To be able to farm and examine the real estate, to be able to rent or lease the real estate, the right to give away and dedicate the real estate, as well as to be able to divide or share, as well as exchange or trade the real estate. So these are all the ownership rights you have when you have a real property interest. Next, we look at the differences between land, real estate, and real property. So in the middle of the page, land. Land is the earth's surface that extends all the way down to the center of the earth and upward to the sky or infinity. This definition includes things that are permanently attached by nature only. Examples of things that are attached by nature only include trees and the soil. Then we see the definition of real estate. Real estate is the earth's surface extending downward to the center of the earth and upward into space. It also includes all things permanently attached to it by nature or man. So, in addition to what we've mentioned already, it would include the physical house, an in-ground swimming pool. It would even include things like a dishwasher that you bought at the store that was attached to the pipes and the plumbing system of the home, so it became part of the real estate. Then we see the definition of real property. Real property combines the definition of land and the real estate that we just noted above, but it includes that bundle of legal rights. So therefore, real property is the earth's surface that extends downward to the center of the earth and upward into sky, including all things permanently attached to it by nature and by people, plus interests, benefits, and the rights included in ownership. In the next paragraph, in various municipalities of southwestern New York, as well as the towns of Boston, Hamburg, Springville, etc., owners sell off some of their rights to areas beneath the earth's surface. So please note, you have the right to do this, especially in rural areas. Of course, you want to verify anything like this with a good lawyer who knows real estate in your community. And that's essentially what the rest of that paragraph talks about at the bottom of 56. I'd like you to look at the italicized area all the way at the bottom. Gas and oil leases are not affected by new ownership because leases live with the property. Just like when you purchase a two-family home, if the current tenants have let's say a 1-year lease and there's 7 months that remain on it at the time of closing, assuming that you sold the property in the middle of their lease, the people that live there can continue. They cannot be evicted or kicked out by the new owners if they have a 1-year lease where 7 months remains. So be sure that whenever you list a property that's multifamily, anything from 2, 3, or 4 units, you want to be sure that you ask about lease information too. That's why we cover that in this section of the program. You want to get not only how much longer the lease remains, but you need to also ask, and make sure you put this in the parking lot section of your notes. That's where we put information that will be used at a later point in the program. You want to make sure that you're aware of when does a current lease end, what's the name of the tenants that are in that lease, and what security deposits are held for that rented part of the property. At the top of page 57, The other type of rights that property owners may sell off or lease separately is that of the air above the land. This is important around areas that are densely populated, such as in cities and numerous municipalities in downstate New York. If you're building in Manhattan, air rights are a huge deal. Second paragraph, there are two types of rights that property owners may be affected by or have with regard to land, which borders on various waterways, which are known as riparian and littoral rights. So in the white area to the left of this paragraph, please write down water rights, so that you know when you see riparian and littoral rights, we're talking about rights of property owners that border some kind of body of water. So riparian and littoral rights refer to property owners' rights who border water. But then we get more specific with the details, and that's in the third and fourth paragraphs. So riparian rights in the third paragraph are the owner's rights in land that borders a river or stream. Think of the first letter in R as riparian and the first letter in river in order to remember the term. We compare that to littoral in the next paragraph. So the L in littoral is also the first letter of lake, L in lake. So that's how you remember the difference between the two. So the R in riparian is for rivers or streams, and the L for littoral is for large bodies of water, like lakes. At the end of the fourth paragraph, property owners who have littoral rights may enjoy unrestricted use of the water, but they own the land only up to the mean high water mark. The government owns all the land below this point. In the next paragraph, riparian and littoral rights cannot be sold separately or kept when the land is sold. That's important to know for test purposes. Where land adjoins streams, an owner is entitled to all the increases that may result from the deposit of soil by action of water or wind. We call this accretion. So on your flashcards, on one side you want to put accretion, and on the reverse side you want to put increases from the deposit of soil by the action of the water or the wind. So again, that's accretion. But in owner, the opposite of accretion is avulsion. So on another flashcard, you want to put avulsion on one side, and then on the reverse side, you want to put loss of land. So the loss of land as a result of the movement of a waterway is known as avulsion, and that's all you need to know. In the next paragraph, we look at the definition of personal property. So personal property is not fixed. Items that are movable or mobile generally meet the description of personal property. So the old-fashioned name for personal property is chattels. You should know that for test purposes. Typical examples include freestanding appliances you might have in the kitchen, like a stove or dishwasher, tables, chairs, throw rugs, etc. Now, dishwashers can be portable if it has wheels on there and it's not permanently attached. But when you permanently attach a dishwasher by connecting the pipes, running the plumbing, doing the electrical hardwired, then we call that dishwasher a fixture. And we define that in the paragraph that follows. So items of personal property can become a fixture when it's been permanently attached to the land or building. It becomes a fixture. So in the paragraph that follows, the definition of a trade fixture is the same exact definition of a fixture that we use in regular residential real estate, but in commercial real estate we call it a trade fixture. Therefore, when you go to a restaurant and you look around and you see stools that are permanently attached to the floor, or you see a counter that people sit at, maybe at a delicatessen, or you happen to see booths. Booths are often permanently attached. At one time they weren't, but once you attach that permanently to the real estate, we call it a trade fixture in the course of a business. In the two paragraphs that follow, we get into more specifics and give you some examples, so please make sure to read that over. At the bottom of 57, we see the term emblements. So fruit, most vegetables, and annual crops of corn and wheat are considered personal property, or emblements. Please note, however, that perennial grasses and bushes that do not require annual cultivation, including trees, are considered real estate with all the rights inherent therein. Let's look at the top of page 58. So trade fixtures remain the personal property of the tenant and may be removed on or before the last day the property is rented. The tenant must, however, restore the property to its original condition. You must repair holes that are left because of screws or nails that were in the wall, and if not removed, they become the property of the property owner. So in the next 4 items, we see the tests, the basic 4 tests, to determine whether an article is considered a fixture or not. And when you read through those 4 items, you'll see that essentially the test of a fixture is if removal of the item will leave any damage whatsoever to the wall that exists, that it was probably a fixture that you had removed. The specific 4 items are: number 1, the adaptation of the article to the real estate; number 2, the method of attachment of the item; number 3, the intention and relationship of the parties; and 4, the existence of an agreement between owner and tenant. So when you start putting together real estate contracts and purchase offers, you should know that there's a whole section of the contract that you want to make sure you review with the broker who sponsors you. The Erie County Bar Association contract, it already comes pre-filled. So it says that if the following items are at the property, they are considered to be included. So you would have to specifically list the items that are not going to be included in the contract. So that means that when you walk through a house with a seller, and this would be right after you list a property, you want to go in and out of every room and try to determine what kinds of things might they not want to include in the transaction, because we're talking about the listing contract. So you want to exclude maybe custom shelving units that you see in the family room, possibly ceiling fans that are quite ornate, and maybe they brought them from Italy and it was passed down from generation to generation and they want to take it to their next property. If things are not going to be included, that you're going to be listing a property and say, let's say the ceiling fans, they got these beautiful ceiling fans. They don't want to include it in the sale. You want to make sure that they swap those out before you actively market that property, so that people don't like to walk into a house and say, oh, this is beautiful, I want it, everything's great, and then they see like a little sign that says not included, not included, not included. You don't want to tease the buyers into all these extra things that they see, but they cannot include it. So it's much better to remove them before they see it. So any shelving units, anything permanently attached to the wall that can be detached and that wall can be repaired like it was never there, you want to do that before you have your first open house, before you actively start marketing the property. The other downside of leaving property there that you don't want to include in the sale is that buyers will try to negotiate it in, even if it says that it's not included. And this way then it becomes difficult, because you hate to lose a spectacular offer because you couldn't negotiate the items that should have been removed in the first place. So hopefully that makes sense to you. The paragraph that follows the 4 basic tests to determine whether an article is a fixture or not gives you another example. In this scenario, it's including an antique hanging lamp and how you would handle that in a transaction. But what I'd like to do now is take a look at the next section where we talk about 5 broad categories of real estate that you should know for test purposes. So the 5 broad categories include residential, commercial, agricultural, industrial, and special purpose. And we'll take a moment to look at each of these now. So residential property is the broadest category we have. The majority of real estate that we would ever transact is residential in nature. It's used for personal dwellings. It's used for rental properties, single and multifamily dwellings, and even vacant land that's zoned for residential use and development, as well as for small apartment buildings. That's also considered in this broad category of residential. Then we have commercial property. And commercial, you should remember, it's property used for non-personal uses. Some of these examples include office buildings and space, retail establishments, if you go to the mall, the theater, parking lots, anything that's non-residential or more than 4 units. Then we see the definition of agricultural. property used for farming, raising cattle, pastures, groves, etc. I think that's pretty clear. Then we see industrial. Industrial are properties such as factories and warehouses, land that's zoned for an industrial use or in an industrial district. That also includes research facilities. And over by University of Buffalo, there's a number of areas that are zoned industrial so that they can do their R&D or research and development. Then at the bottom of 58, we look at special purpose. Special purpose properties are those different from all the categories noted above. And the most common examples, if you get a test question that says, which of the following options would reflect a special purpose property? What you want to know for test purposes would be schools, cemeteries, churches, hospitals, and even government property constitutes special purpose use. Now we're going to take a look at some video components to reinforce what we've just covered.
Sometimes there's a misconception about what's personal property and what's real property or real estate. Now, obviously, the house is real estate and the car in the garage is personal property, but it's not always quite as easy as that. For example, the refrigerator generally comes with the house, but the washer and dryer may not. I was representing a buyer once, and she asked if the very ornate bathroom mirror stayed. The listing agent looked at me curiously and said, it's the bathroom mirror. Well, moving day came and the mirror wasn't there. Clearly, you're not going to remove the refrigerator or the washer and dryer if you're planning on taking them with you. But what about your grandmother's chandelier or those curtains that'll work perfectly in your new home? I suggest you just take them out and replace them with something else. When flat screen televisions first came on the market, there was a huge discussion about whether they were personal property or real property. After all, they were generally attached to the walls and oftentimes hardwired into the internal system. Now, we now accept that they're personal property and it's not an issue, but you can see how it can be more confusing than what it really should be. The reality is, if you're planning on taking something with you, just replace it. And if you can't replace it, make sure you fully disclose that it will be gone when you leave. That way there are no surprises.
So when it comes to buying or selling a home, it's really important that both the buyer and seller have a complete understanding of what's going to be sold with the property. And so when you sell a house, you have your real estate, the real property, which is like the walls and the ceiling and the roof. Everybody knows that that's real estate. And then you have personal property, like this coffee cup, or this chair, or this pillow. That's my personal property, and of course, as a seller, I would take that with me. Where confusion happens is when personal property is attached to the property, and then it becomes a fixture. And the definition of fixture, in order to define a fixture, is we kind of have some tests. So one of the questions we ask is, how is the method of attachment? Is it glued to the wall? Is it screwed in? How is it attached? So let's take a closer look to examine attachment. So curtains and window treatments are always some area of confusion there. So let's clear this up. Blinds. Blinds are attached to the property. So would they be real or personal? That's right, they're real because they're attached. They would stay with the house. Then you have the hardware that the drapes are attached to. Now those are screwed into the wall. So would they be considered real or personal? That's right, those are real property. So the hardware stays with the home. Then you have this drape. Okay, this drape is movable. I can easily slide it off of that hardware. So would this drape be considered real or personal? That's right, this is personal property. But let's say another test that we have for fixture is what we call adaptability. And what that means is, was it created or adapted for the house? So pretend that I had a valance that was on a board, custom made, all done just for this window. It fits specifically on this window. That was adapted for that window. So do you think that that custom made valance would be considered real or personal? That's right. That would be real property because it is the intention was for that to be there. Another great example is a floating floor. A floating floor is not attached to the property, but its intention was to be part of the real estate. So let's look at another test. The last test is intention, and what was the intention when you attached it to the property or made it for the property. So a great example is bookcases. Built-in bookcases, the intention is that they are part of the real estate. But the question can be, or that situation can be cloudy. Let's talk about this 55-inch screen TV that my husband installed on our wall. Is it attached? Yes. Right? Was it his intention to leave his 55-inch screen TV for the next client, or the next buyer? Probably not. So this is a little confusing because this is attached to the wall. What I want to say is, if you're a seller and you are in love with your 55-inch screen TV, then I would either tell you to put in the real estate disclosure that that is not included in the sale, or better yet, to actually take it off the wall and not have it there. Because if the TV is there, the buyer's going to see it, they're going to see how awesome it looks here, and they're going to want it. And you're probably not going to get to keep it. They're going to try to negotiate that into the offer. If you're the buyer, and there's any question as to whether it's going to stay or not, when in doubt, write it out. Put it in the contract that that TV stays. Otherwise, you may get there and think the TV's going to be there, and you walk in on that last day and the TV's gone. So when in doubt,
One way to
write it out.
understand property law is people's rights concerning. You'll probably learn about two major types of property law. The first is real property law, which concerns land and everything attached to the land. The second major type of property is personal property, which are things that are not attached to the land. So what do I mean by rights concerning things? Well, let's say Ollie buys a house. Buying the house gives Ollie a number of rights concerning the house and the land that it's on. For example, Ollie probably has the right to put a swimming pool on the land. He can probably exclude people. He should have the right to sell the land and the house. But Ollie doesn't have unlimited rights. For example, he probably doesn't have the right to turn the house into a zoo. Ollie's rights to the land are best understood in relationship to other people's rights to the land. Let's say Ollie allows Tom to stay in his house as a tenant. Tom will have certain rights to use the house. Tom may also have the right to exclude people from the house. Of course, Ollie might have rights that Tom doesn't have. As an example, Ollie has the right to sell the house that he bought. Tom, the tenant, does not have the right to sell Ollie's house.
Two type of water rights that I'd like to pass on for you, and they're so easy to get these two confused on the exam. And the first one is the riparian rights, and the riparian rights work like on a small body of water that is non-navigable. So if we have a pond and there's a house like this, theoretically, if their body of water is non-navigable, your rights extend for your riparian rights to the midpoint of the water. However, if the water is navigable, and fortunately for you, you won't have to determine whether a piece of water is navigable or not for the exam. You're not taking the Coast Guard exam, you're taking the real estate exam, so they'll probably tell you, or it will be self-evident. But in that case where it's navigable, your rights extend to the water's edge right there, whereas if it's non-navigable, they extend to the midpoint. And for this type of right, you're allowed to achieve a certain extraction of water for basic homeowner purposes, and so that you're not actually disturbing anybody else's right to the water. Although local state laws are going to vary. So let's take a look at how it works with littoral rights. Littoral rights. Yep, they're much better. You know, I'll draw a little diagram here. Actually might change our pen color. If we have the ocean down here, there's the ocean, and we'll say it's low tide right now. At any beach that you go to, there's always going to be this, turn a little green here, little row of seaweed and rocks, of course, and that type of thing. And that's where the tide usually comes up to be. That's going to be called the mean high water mark. In this particular case here, your rights extend, if you had your house up here, there we go, your rights are going to extend to the mean high water mark if you live by a large body of water, for instance, an ocean, of course. And when the tide comes up, it's going to usually come to this spot here, and your rights as the landowner usually go to this point here. So if you're traveling left to right here below the mean high water mark, you are technically not interfering with the littoral rights of the property owner.
Timothy,
here.
we should follow this river for a while. I really like walking on this soft river bank.
This river is very broad and has been running through this region for several years now.
I suppose the layers of this soft riverbank have formed over time as small amounts of clay were added to it by the river. That's what I studied in school anyway.
You're right. The accretion of clay and soil has made this a fertile riverbank.
You can see that from the lush vegetation growing here.
Water rights that go with the land are considered real property. These water rights include the right to make reasonable and appropriate use of water on, under, or adjacent to the land. The owner of a property bordering a moving water source like a stream or river has riparian rights. Riparian property owners have reasonable use of flowing water, as long as such use does not injure other riparian owners' rights. If riparian property owners want to dam or divert water, they must have permission from the local flood control authority. Owners of land bordering a lake, pond, or ocean have littoral rights. Littoral rights are usually concerned with the use and enjoyment of the shore. When there is a need for the government to divert water for public use, its right of appropriation is applied. Appropriation is the right to use water for a beneficial use by diverting surface water. Riparian and littoral owners may experience the increase of land by construction or nature. The increase of property is called accession. Accession can occur by construction or by the process of reliction or accretion. Reliction means the gradual recession of water leaving the land permanently uncovered. Accretion means the gradual buildup of soil by water to land. This soil is called alluvion. Alluvion is the material that builds up. Riparian and littoral owners may experience the decrease in land by natural forces as well. And there are two kinds of this. One is called ablution, which is a sudden loss of land by the actions of water or nature, like a landslide. Ablution means to tear off. This is also a medical term, and I don't recommend that you Google it. The other one is called erosion. The meaning of erode is to deteriorate. So, erosion in real estate means the gradual loss of land by the actions of nature, like property lost along the bank of a river.
Emoluments are annual crops produced by cultivation legally belonging to the tenant, with the implied right for its harvest, and are treated as the tenant's property. They are considered personal property. A tenant farmer has the right to his crops even when his lease ends before the end of the growing season. Crops grown on property just before it's sold generally are considered to be the personal property of the seller as well. Remember that personal property goes with the person. This comes into play in the law of landlord-tenant or in the foreclosure of mortgages and other legal situations that place the rights of another party in contention with those of a farmer who has planted a crop yet to be harvested. In these situations, the doctrine of emblements operates to guarantee the farmer's rights to reap and carry away the fruits of his labor, even if he loses title to the land on which they are grown.
Sam became angry because a fisherman was fishing on the lake in front of his property. He yelled,
"Get off my property!"
But the fisherman just ignored him and kept casting. Sam didn't understand why the fisherman didn't listen and decided to ask his friend about his water rights.
"Marley, why didn't the fisherman move when I asked him to?"
The fisherman is allowed to fish in front of your property because of riparian water rights.
What is that?
Well, riparian water rights are a system for allocating water among those who possess land along its path. Under riparian law, water is a wandering thing like the air, sunlight, or wildlife. It is not owned by anyone, rather, part of land over which it falls from the sky or travels along the surface.
So the lake space in front of my house doesn't really belong to just me?
No, in fact, the water is split among all of those who own property on the lake.
What do these rights include?
They include the right to swim, boat, fish, drink the water, use it as irrigation, or to put in a dock or lift.
So I can use all of the water in the lake, even though others live along its border as well?
The law states that riparian owners are permitted to make reasonable use of this water as long as it does not unreasonably interfere with the reasonable use of others with riparian rights.
Do riparian rights only account for certain bodies of water?
No, riparian rights are present for all bodies of water that have people living along its border. This includes streams, lakes, ponds, and even oceans.
Do riparian rights exist in all countries or just the U.S.?
Most countries regard the water as a state property, where in the U.S., the public aspect of water is distinguished by riparian rights, which are considered to be private property rights and are protected against governmental seizure by the U.S. Constitution.
So when were these rights created?
The English water law first adopted in the U.S. was premised on the natural flow doctrine. This said that any riparian owner had the right to a natural water flow of unlimited quantity. Then, by the mid-19th century, almost all American states had stopped using this doctrine and adopted a second doctrine, which called for reasonable use instead of unlimited.
Are riparian rights the only water rights in the U.S.?
No, there is also the prior appropriation doctrine. This doctrine states that water rights are determined by the priority of beneficial use. Basically, it rests on a first-come, first-served basis. The first person to use the water or divert water for a beneficial purpose can obtain individual rights to the water.
Next, we begin on page 59. We look at freehold and leasehold estates. Now, the pages that follow are some of the most confusing parts of the program for students, and I'm sorry there's really no super easy way to remember these. There's a lot of memorizing. It's some of the most difficult parts of the course that are coming up, and it's also where a lot of your exam questions come from, both on the school and the state exam. So let's look at the two broad categories. We've got freehold and leasehold estate. And if you could be so kind, in the top empty area of your page 59, write down that freehold states last an indeterminable period of time. In other words, there's no definite ending to most freehold estates. And that's compared to leasehold estates that are for specific periods of time in general. You know, real estate is a lot of, well, let's put it this way. Real estate is not a lot of black and white. When we welcome you to the world of real estate, we're welcoming you to the world of everything is gray. Everything's a shade of gray. So it's hard to pinpoint a number of things, and that's just the way it is in real estate. It's always been, and it always will be. So we know that a freehold estate is for an indeterminable period of time compared to a leasehold estate that's generally a determinable period of time. So in the first paragraph of 59, in real estate, the amount and kind of ownership that we refer to as a real estate interest that a person has in real property is called an estate in land. So When we have an interest in real estate, it's generally a type of estate in land. Estates in land are either freehold estates or leasehold estates. A leasehold estate generally pertains to rentals and leases, which is nice because lease, the word lease is in leasehold. So it's easy to say that a leasehold estate pertains to rentals and leases because the word lease is in it. As you continue that paragraph, a freehold estate exists for a lifetime or forever. There are 4 types of freehold estates that are recognized in New York. Fee simple. Number 2, qualified fee. Number 3, fee on condition. And 4, a life estate. Now the most common type that you'll run into in real estate are number 1 and 4. The majority of the real estate we transact in Western New York and most of New York State is a fee simple estate. We have some really good video segments that also reinforce this material. The other most common type of estate that you are going to run across in New York is a life estate. And when you pull up property tax records and you look to make sure that in fact the people who called you to do a market analysis because they're thinking about selling their home, you're going to be able to know in most cases if their lawyer did everything correct, you're going to know whether or not there is a life estate on that property that's going to affect your transaction as far as being able to list it. Because if there's a life estate and you sell the property and someone has a permanent right to live there for the rest of their life, you don't really want to sell that property. You want to bring this to your sponsoring broker's attention and say, Houston, we have a problem. And when you look at property tax records, the way to know that there's a life estate is that it will say under the owner's name, it will have the person's name and then a comma, and then it'll have either capital L-E. Now you're not tested on this. The state will not test you on how the property records will look. The state only wants to know that you know what a life estate is, a fee simple estate, all the different ones we talk about. That's all they want you to know. The way you know, though, for your own personal reasons, because remember, we want you to get more out of the course than just how to pass the exam, is you'll see either capital L-E after their name, or you'll see the word life and then EST abbreviated after their name. And if you see that, you immediately want to bring to your broker's attention the fact that you're going on a listing appointment and there's a life estate, and this is what you saw. Let's take a look at the second main paragraph of page 59. The first 3 of these estates continue for an indefinite period of time and can be inherited after the owner's death. A life estate, which is number 4, is typically set up in conjunction with a will. It ends at the death of the person on whose life it is based. So that's important. It ends or terminates at the death of the person whose life it is based upon. And that person can also give up their rights to the life estate. They can terminate it. They can terminate it, though. No one else can terminate it after it's been created. Then let's look at the bold area where it talks about leasehold estates. A leasehold estate is an estate for a specific period of time, and then they're classified as follows. So we have an estate for years. We commonly establish this estate for years by a lease, written, or for a period of less than a year, it may be a verbal lease. An estate for years gives a tenant possession of the property for a fixed time, but not necessarily for years. So just because it's called an estate for years, it doesn't have to be for years. And this is a good time for me to let you know that we have a lot of phrases in real estate that are very misleading, because we say for years, but it doesn't have to be for years. In the next section, the following estates last for an indefinite period of time: a periodic estate, an estate at will, and an estate at sufferance. So first thing we do at the bottom half of 59 is we look at the most common type of estate that we have in real estate. The majority of what you'll be doing as a residential real estate agent will be the transacting of fee simple estates. And in real estate, a fee simple estate is exactly what you want to get. It's the most complete type of ownership you can have. And that's a phrase that you want to know for test purposes. We have that in bold. It's no accident that we have that in bold. So the most complete type of ownership in real estate is a fee simple estate. So on one side of your flashcard, you want to put fee simple estate, and on the reverse side, you want to put most complete type of ownership you can have in real estate, period. Let's continue with that paragraph on 59. A fee simple estate is one in which the owner is entitled to all rights in the property. There is no time limit. It is said to run forever. On the death of its owner, the estate passes to heirs. In New York, a grant, through a sale or gift of real property, automatically transfers fee simple ownership unless the terms of the grant show a clear intention to convey a lesser estate. Other names at the end of that paragraph, there's other names for a fee simple estate, because it would be too easy if we just had one name for everything. And the real estate industry and everything related to it, from appraisal to home inspection, everything I've ever been involved with, always has multiple names for everything. It's just the way real estate is. So absolute fee simple, fee, and fee simple absolute are other variations of the same name, fee simple estate. Next paragraph. Occasionally, upon a transfer through gift or sale, the grantor provides that the real property must be used for a specific purpose. For example, if the deed stipulates that the property can only be used for hunting and recreational purposes, and the grantee, now that's the one who acquires the property, and I'll talk about that in a moment. And the grantee uses the land in a different way other than for hunting and recreational purposes, the ownership would automatically revert to the previous owner or qualified heirs. This is an example of a qualified fee estate. So please understand that for test purposes. So in that paragraph, we use the term grantor and grantee. The grantor is the person selling the property. So grantor is the current owner selling the property. The grantee is the new buyer, the person who's purchasing the property. So the buyer or the purchaser of the property is the grantee. The grantee will become a grantor when they turn around and sell the property later on. Also know that deeds are signed by the grantor only. When a person purchases a home, they don't sign the deed until they become the grantor. So the deed that the buyer receives is always signed only by the grantor, the current owner. Let's look at the third paragraph from the bottom of 59. A fee on condition is somewhat different. The deed transferring ownership might have been worded so that if the land were ever used for any purpose except hunting and recreational purposes, then the land would not automatically revert back to the previous owner. The previous owner, known as a grantor, would, however, have the right to file a suit in court to recover the property. And then we have a life estate. A life estate is limited to the life of a specific person. The owner does not have the right to pass ownership to heirs because the life estate ends with someone's death. So the person who sets up the life estate provides for the future ownership of the property. After the death of the life tenant, the property reverts to the original owner or passes to someone else. In the video segments that follow, it'll reinforce almost everything on this page, and it should be crystal clear to you after that. I also want to point out to you that a lot of this weird stuff is weird stuff. It's not the most common thing you'll see. A fee simple estate is the most common freehold estate you'll see. End of story. After that, the next most common freehold estate that you'll see would be a life estate. So please know for test purposes, fee simple and life estate are the most common ones. You do have some questions that involve understanding what a qualified fee estate is or a fee on condition, but that's only because New York might ask you that. It's not because you could likely run into it. The most likely opportunities to run into this weird stuff would be commercial real estate. But since most people sell residential, you're really not going to see it for maybe ever. At the top of page 60, we see the terms remainder interest and reversionary interest. I'd like you to give that a review on your own. We don't hear a lot of that on the state exam, but we'll also have a little video segment that will reinforce that for you too. But I want to talk about the third paragraph of page 60. A life tenant cannot, however, permanently damage or change the land or property. A life tenant is entitled to all the income and profit that arises from the property. A life estate could theoretically be sold, leased, or mortgaged, or even given away, but it will always terminate or end at the death of the person whose life the estate is measured on. There's something I'd like you to write down, though, next to that paragraph where it says life tenant. Okay, so next to life tenant, please write this down. When you have a life estate, suppose, your mother sets up a life estate where she would be the life tenant and she puts the house in your name and her children's name. The children of the person who has the life interest or the life tenant is called a remainder man. So remainder man, the terms that we discussed above, and you'll see more about that in the next video segment. In the middle of page 60, we see the term fee simple estate. And a fee simple estate, we know, falls under the broad category of a freehold estate. There's 3 different ways that a fee simple estate in land can be held. Number 1, in severalty. Number 2, co-ownership. And number 3, in trust. So, in severalty means ownership by one. The title is held by one owner. Don't let the term goof you up. Severalty equals one owner. So on your flashcards, you put severalty on one side, ownership by one on the other. The next most common test question we see is in trust. So the trigger word, so this would go on your flashcard. On one side, you put title held by a third person. On the other side of that, the term is trust. So when something is in trust, you always have to use the phrase third person, third something. If it's being held for the benefit of or by a third person, we're talking about in trust. You might say to yourself, why would anyone even want to do a life estate? Well, there's 3 big reasons. Number 1, in order to avoid probate. A life estate's an easy way to pass your home to your children or other beneficiaries without going through the probate process. If you own a home and the title is in your name alone at death, it has to go through probate. So keep in mind that having a will does not avoid probate. It simply tells a court how to distribute your property in your estate. But a trust, however, does avoid probate, as does property held in joint names with rights of survivorship by spouses as tenants by the entirety. These are other terms we're going to see in a moment. Also, another reason why people would want a life estate would have to do with tax planning, because retaining a life estate in your home means that it remains an asset of your estate for estate tax purposes, and it allows your children to receive what is known as a step-up basis in the real estate. So this means that they inherit the property at the date of death, not the value as of the date upon which you acquired the property. So when your children sell the property, they should be able to avoid capital gains unless, of course, the property appreciates to a value greater than the date of death value prior to the sale. The other main reason why people get a life estate is that they want to preserve the home for long-term care planning purposes. In other words, if they're going to land up in a nursing home, your parents are going to land up in a nursing home, this helps to limit some of the transfer rules that are in place for eligibility purposes for Medicaid and other things after what they call a 5-year transfer period. That's what it is currently, and it was actually increased from a lesser number years ago. In the middle of page 60, the form by which property is owned is important to real estate licensees for a couple of reasons. Number 1, the form of ownership existing when a property is sold determines who must sign the various legal documents involved. Number 2, the purchaser must determine in what form he or she wishes to take title. In the next section, it's not an accident why we have it in bold and capital letters. We never want you to play lawyer, even though you've got to know all these laws and regulations. It's really to help trigger, I better get a lawyer involved or ask the right questions. So when legal questions arise, request that the parties involved seek competent legal advice. If you find a property owner saying to you, hey, do you think I should get a life estate, blah, 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 that you really want to make sure that you don't have these conversations with them based on what you've learned in a 75-hour real estate course. You want to make sure that you run questions like that by your broker and say, you know, what do you want? What should I tell these people? Because in many cases, the best answer will be you should really speak to your family attorney to get advice, because there's usually tax consequences that you don't want to get. You don't want to get in trouble for giving people advice or that they misunderstand you. So always have the caveat of that you recommend speaking to an attorney. Be very careful about giving advice that could affect the long-term tax and financial consequences that go above and beyond what we cover in the course. You know, we cover in the course how to value the property, how to get people the most for their money, and lots of questions to ask in order to help people make better decisions. So make sure you don't deviate from that too much. At the bottom of page 60, we look at the third paragraph from the bottom. Severalty is the ownership of property by one person only. Ownership is severed or separated from the form of co-ownership and is also referred to as sole ownership. When the owner dies, the property passes to the owner's heirs or qualified distributees. Next paragraph. When title to one parcel of real estate is owned by two or more persons or organizations, those parties are said to be co-owners. So New York State recognizes three types of tenancies. So the first one is tenancy in common, 2 is joint tenancy, and 3 is tenancy by the entirety. And I'd like to see you take your pen or whatever you're writing with and connect 2 and 3 together, because there's a connection between 2 and 3 that doesn't exist with number 1. So you draw a little line to connect 2 and 3, and then next to that line, please write down rights of survivorship. Again, that's rights of survivorship. So joint tenants and tenants by the entirety both have the rights of survivorship. Tenancy in common does not have the rights of survivorship. Now we're going to look at them. A tenant in common at the bottom of 60, a tenant in common owns an undivided interest in the property. Although an owner may say have 50% or 1/3 interest in a property, it's impossible to physically distinguish which specific section of the property is owned. So the deed that creates a tenancy in common may or may not state the percentage or fractional interest held by each co-owner. So if no proportion is stated, each owner owns an equal share. If there's 2 owners listed as co-owners, it's 50-50. If there's 3, it's 33% each. In the last sentence, page 60, upon the death of a co-owner, his or her interest passes to chosen heirs or devisees, a continuation of tenants in common. If you turn the page 61, we look at tenants in common. They can sell, convey, and mortgage or even transfer their interest without the consent of the other co-owners. That you should know for test purposes. That's why we have it bold and in italics. So tenants in common can sell, convey, mortgage, or transfer their interest without the consent of the other co-owners. So in New York State, a conveyance, whether through sale or a gift, to persons who are not married to each other automatically creates a tenants in common unless it's otherwise stated in the deed. When 2 or more people inherit real property interests, the relationship recognized as tenants in common unless it's stated otherwise. So based on the parameters that we're outlining right now in this section of the program, when you get your hands on deeds for properties that you're listing and selling, it's going to be really important that you look it over, because when you start seeing these phrases, you'll say to yourself, oh, okay, I remember we covered that at Western New York School of Real Estate as far as tenants in common, joint tenants, etc. It has real ramifications. It lets you know whether you have the right to even deal with that person or not, based on everything else we've mentioned so far. So let's look at joint tenancy and the rights of survivorship, because we know automatically now that joint tenants and tenants by the entirety both have the rights of survivorship. So the rights of survivorship mean that if there's 2 owners and it's joint tenancy and one of them dies, the remaining person gets their balance. It's not like that in tenants in common. Because if there's two owners and it's tenants in common ownership, if there's one person that dies, that person's heirs will inherit what that person's ownership was, that other 50%. The other tenant doesn't get the person's inheritance unless they happen to be willed it, which would be fine, I guess. But normally, this kind of, I'll tell you when you run into this. There's so many people that are getting married 2 and 3 times in life. And there's a lot of people that get married later in life, in their 60s and 70s. And sometimes those people getting married in their 60s and 70s were divorced in their 30s or 40s or 50s. So when they get divorced, they own the property on their own, sole ownership, so the tenants in common. And then they go ahead, sign up for Match.com or Christian Mingles, and then they meet the man or woman of their dreams. And they fall in love, and next thing you know, you hear wedding bells, and now they've got a house situation to deal with. Matter of fact, they both might own their homes separately. So what do? Well, they probably sell one of the houses, and then the other one moves into, the other person moves into. And that's if they get married. They may decide that it doesn't make sense to get married because they're going to affect their pension or their Social Security could be affected. So, they may just cohabitate and say, heck with the whole marriage thing. We've already both been down that road. So one of them still might sell their house, move in with the other one that they're going exclusively, dating exclusively now. And if they're living together, but they want to really secure the relationship, they might say, hey, you know what? I want to put your name on my house. So then if they're tenants in common and they don't know the difference between the two, when that person dies, that interest of the name of the person that they added, the parent who died, they get 50% of that property. But if they go under joint tenancy, then the other remaining significant other will get the rest of the inheritance from the person who died, as compared to their kids getting it, the kids of the person they were dating, if you kept my story straight at all. And I think the video components might help out as well. But if you don't really get what I just said, feel free to jot it down and we'll talk about it afterwards. So let's look at the second paragraph of page 61. The basis of joint tenancy is the unity of ownership. The property is owned by a group made up of 2 or more people. The death of one of the joint tenants simply means there is one fewer person in the group. The remaining joint tenants automatically receive the share owned by the deceased tenant through the rights of survivorship, no matter what that person's will might have ordered. That's huge concept. Only the last survivor who becomes a sole owner may dispose of the property by will. Next paragraph, to create a joint tenancy in New York State, language in the deed, again, language in the deed must specifically state that title is taken in that form of ownership. So that's really good, because now when you see a deed, it'll have to specifically say as joint tenants. If it doesn't say in joint tenants, then it's tenants in common. Next paragraph, tenants in common or joint tenants may file in court what we call a suit to partition. So a suit to partition the real estate is a way to legally end the co-ownership when the parties don't agree. If a court of law determines that the real estate cannot be physically divided, it will order that the real estate be sold and the proceeds divided among the co-owners. And believe me, this has happened in courts around the country. In the next section, we look at tenancy by the entirety. So on your flashcards, you want to put on one side tenancy by the entirety, and then on the reverse side, you want to put down husband and wife with rights of survivorship. Again, that's husband and wife with rights of survivorship. So a tenancy by the entirety is a special joint tenancy between husband and wife. The owners must be husband and wife when they receive the property. They have rights of survivorship, but there's no right to partition. The reason why there's no right to partition is because that falls under tenants in common. You shouldn't even set up the whole tenancy by the entirety thing if you don't want to go for that. but how do you even understand the differences unless you have a good lawyer representing you that explains it, or you came through a program like this where you learn it in class? I know I had never learned this before I got into real estate. This was not part of any of my college curriculum, and it wasn't covered in any of my management classes. As a matter of fact, I don't even remember it being in my business law class, which is a common class that people have the option of taking when they're going for a management degree. Next, we look at the fourth paragraph from the bottom of 61. In New York, a conveyance to a married couple automatically creates in them a tenancy by the entirety, unless the deed states otherwise. A divorce will break the tenancy by the entirety, and the ex-spouses immediately become tenants in common. So please know that. Property owners may provide for their own financial care and that of others by establishing a trust. Such trusts may be created by agreement during a property owner's lifetime. We call that a living trust. Or established by will after the owner's death. That's known as a testamentary trust. Next paragraph. Ownership by a business entity makes it possible for numerous individuals to hold an interest in the same parcel of real estate. The ownership may be organized in various ways to finance the real estate project. So now we look at 4 different ways that business organizations can be categorized: sole proprietorships, partnerships, corporations, and syndicates. Typically, a sole proprietorship is the easiest and the simplest of the 4 business organizations to establish. A sole proprietorship is a business owned by one individual. Establishment of this type of business form is through a record search of the county hall to verify the name of the business that it's not already in use, especially if the sole proprietorship is a DBA. DBA stands for doing business as. It's under an assumed name. Once it's been verified that the name is available to use, the sole proprietor prepares a DBA form and has it notarized, and then you file accordingly with the county hall. Next paragraph, page 62. An association of 2 or more people to carry on a business as co-owners and share in the business profits and losses is known as a partnership. Now, there's a couple items here it's really important to know for test purposes. Partnerships are classified as general and limited. In a general partnership, all partners participate to some extent in the operation of the business and may be held personally liable for losses and obligations. A limited partnership includes general partners as well as limited or silent partners. The business is run by the general partner or partners. The limited partners do not participate in the daily operation of the business. Limited partners can be held liable for the business losses only to the extent of his or her investment. So there's a couple important things you really have to keep straight in this paragraph. So if you hear the phrase general partner, know that the individuals can be liable, personally liable for business losses and obligations, and they're involved in the operation of the business, the day-to-day operation of the business. However, a limited partner is not someone that can be involved in the day-to-day operations of the business, and they can only lose the amount of his or her investment. So please know that, and feel free to repeat the section over again to make sure you keep it straight. We cover this in the program because limited partnerships in the next sentence is a popular method used to organize investors for large real estate projects. Now, if there's a general partnership and the general partner dies, the partnership is just dissolved. That's all that can be done. In the next paragraph, we talk about a corporation. There's almost always a corporation question on the exam. An artificial entity created under the laws of the state from which it receives its charter is a corporation. There's lots of different corporations, and we're going to review that in some of the video segments that follow. So no, when you hear the phrase artificial entity created under the laws of the state, there's actually no other phrase that starts with the words artificial entity anywhere else in the real estate program. So if you remember artificial entity and put that on one side of your flashcard, then on the other side put corporation, that's all you need to really answer a question. Especially because your brain is going to fill up with all these terms that you have to memorize Why not put these trigger words in the fewest number of words necessary to remember? Let's continue that paragraph. Because the corporation is a legal person, real estate ownership by a corporation is ownership in severalty. A corporation is managed and operated by its board of directors. As a legal entity, a corporation exists indefinitely. Another way of saying indefinitely is in perpetuity. The death of one of the corporate officers or directors does not affect the title to the property owned by the corporation. Next, we look at individuals. Individuals participate or invest in a corporation by purchasing shares of stock. Because stock is personal property, stockholders do not have direct ownership interest in real estate owned by a corporation. So each stockholder's liability for the corporation's losses are usually limited to the amount of investment that you have in the stock. And then we see the term syndicate. A syndicate is a joining together of two or more people or firms to carry out one or more business projects. It may be organized into a number of ownership forms, including co-ownership, which is tenancy in common or joint tenancy, partnership, trust, or corporation. So we compare and contrast now the difference between a joint venture coming up and the syndicate we just covered. So a joint venture is an organization of two or more people or firms to carry out a single project. So on one side of your flashcard you put joint venture. On the reverse side you put down two or more people to carry out a single project. Two or more people to carry out a single project, and that's for joint venture. Then on another flashcard, you put a syndicate on one side, and on the other side, two or more people to carry out one or more business projects, period. So syndicate is for one or more projects. Joint venture is always a single project. Always, always, always. We go further in that paragraph and state that a joint venture lasts for a limited time and is not intended to establish a permanent relationship. Now we're going to review some video segments to help reinforce the learning process.
A person can own assets by themselves, which is solely, or they can own them as joint tenants or tenants in common. Now these are old legal phrases, nothing to do with leases and tenancies. They're actually the two ways in which people can hold joint assets. So if you're dealing with probate, this could apply to bank accounts, houses and other assets, and it's essential to know the differences because they're treated very differently. Taking the example of a house, it may have been owned solely by the deceased. In that case, it will pass to others or be sold according to the will or intestacy. A grant of representation is required to sell or transfer the house, and the whole value is added to the estate for inheritance tax. If the house was owned jointly as joint tenants, then the deceased share will pass to the surviving joint tenant or joint tenants automatically on death. This is called survivorship. The deceased share does not pass according to his will or intestacy. It passes to the survivor regardless of what the will says. A grant of representation is not required. The value of the deceased share is added to the estate for inheritance tax. Alternatively, if the house was owned jointly, it may have been owned as tenants in common. Unlike joint tenants, the deceased held a defined share in the asset. That doesn't mean he owned particular rooms in a house, but he owned a fixed percentage, for example 50%. The deceased share does not pass automatically to the survivor or survivors. It passes according to a will if he had one, or if he didn't, by the rules of intestacy. For example, if a deceased left the entire estate to his children in a will, then his share of the house will pass to them. They will then own the house jointly with the surviving tenant in common. A grant of representation is required to deal with this share, and the value of the deceased share of the house is added to the estate for inheritance tax.
Good morning. I found this great cabin in the woods. How about you and me buy it together?
You and me?
Yeah. Pull our money, buy it together. It'll be half yours, half mine.
You know we gotta be careful how we set that up.
Why is that?
Because there's different ways to own property, and it can cause some real legal problems.
Like what?
Well, let's say how we set it up in the first place. We buy the property as joint tenants, or if we buy the property as tenants in common.
Who cares what we call it if we buy it together? Those are just words on paper.
Well, we should care, for one, because, I mean, if we buy it as tenants in common and one of us happens to die, where do you think the other interest goes?
It goes to the other one.
Not necessarily. See what I mean about how we set it up? If we buy the property as tenants in common, then if one of us dies, it doesn't go to the other one. It goes to that guy's heirs. And I don't know about you, but I have a problem with my interest being in the hands of your crazy sister.
Well, there's some people in your family I'm not so happy about either.
All the more reason for us to set it up right. You see, if we set it up as joint tenants, then if one of us dies, the other one gets full title. And that's what you want, right?
Now you're talking. What if one of us decides to split up ownership, though? Don't get me wrong, I don't think it'll happen. But what if it does?
Well, in both tenancy in common and joint tenancy, owners can partition the property.
You're not talking about splitting it down the middle, are you?
Well, if it was land, that'd be okay, but usually with property, we'd have to find a buyer and then we'd split the profits.
What if one of us gets married?
That's a good question. Probably because our ownership predates the marriage, it probably wouldn't be considered marital property. But I don't really know.
We buy it as joint tenants.
There's only one problem.
What's that?
I don't have any money.
Let's review how tenancy in common works. We've got Harold and we've got Maud. With a tenancy in common, whatever interest each party owns is his or hers, to do with whatever he or she wants, almost as if there is an imaginary line separating their ownership interests. So, Harold can keep, will, or sell his interest, and Maud can do the same. Keep, will, or sell.
Brian?
Yes, Maud.
Do I need to get Harold's permission to sell or will my share?
No. Either one of you can will or sell your share without the other's permission.
What if Harold dies?
Hey.
What? I need to know. What would happen to his share if he died?
Well, Maud, because you are tenants in common, when Harold dies, his share will go to his estate.
I'm sorry. Could you be a little more specific?
Yes. His share of the property will go to whoever he names in his will, as the devisee.
But, I thought his share would go to me, as the spouse.
No. With a tenancy in common there is no right of survivorship, and, in the event one of the parties dies, that party's share goes to his or her estate.
Oh. So, I would own the property as a partner with whoever Harold wills the property to?
That's correct, and the new owner would have the same rights as the
a married
previous
couple,
owner.
There are many things you share. Home, car, income, sometimes toothbrush. Property can also be shared. A shared investment, that is, in the eyes of the law. And as a married couple in the eyes of the law, you can be considered as one single investor, sharing equal ownership of a piece of real estate. This is called tenancy by the entirety, or tenancy by the entireties in legalese. Each person in this shared ownership is called a tenant by the entirety. Even though it uses the word tenancy, it has nothing to do with renting property from a landlord. Here, tenancy means being an owner. Tenancy by the entirety only applies to couples who are married to each other. Tenancy by the entirety potentially affects a number of different legal issues, not least ways when it comes to issues of probate. Probate court has to do with wills and assets belonging to the deceased. For property owned through tenancy by entirety, the surviving spouse automatically gains full control of a deceased spouse's share. Getting back to the business of living, however, we also see that tenancy through entirety prevents one spouse from selling the property, such as real estate, without a signature from the other. Now, if a creditor sues just one of the spouses and attempts to reclaim debt, anything owned through tenancy by entirety is off limits to collection. There are some additional requirements for a property to be considered tenancy by entirety, outside of just being married. 1. The couple must have already been married when the property was acquired, and the mutual interest in the property must have taken place at the same time. Basically, tenancy by entirety is a shared venture all
Freehold
the way
estate
through.
is an estate in which ownership is for an undefined length of time. The three types of freehold estates are fee simple absolute, fee simple defeasible, and a life estate. Fee simple absolute is the greatest interest in a parcel of land that one can possibly own, sometimes designated simply as fee. This form of ownership cannot be defeated by the previous owner or the previous owner's heirs. However, it is not free from encumbrances. Fee simple defeasible is an estate that may be owned for an undefined amount of time but possibly may be voided at a later date because a condition was violated. The estate has the possibility of being defeated, hence defeasible. For example, Bob conveyed title to Andrew with condition that if Andrew sells alcohol, the title will go back to Bob. A life estate is an interest in real property, which is held for the duration of the life of a designated person. It may be limited by the life of the person holding it or by the life of another person. For example, Anne can give a property to Dan for the life of Anne. Dan would be the life tenant. A life tenant receives the property and is responsible for maintenance of the property and for paying taxes. If a life tenant allows a property to deteriorate, it would be committing waste. A life tenant cannot commit waste. A life tenant also cannot leave property to anyone in their will. A life tenant may sell, mortgage, or lease the property for the duration of the estate. Thus, all contracts would be terminated upon the death of the life tenant. If Dan dies and the property goes back to Anne, Anne would have the estate in reversion. But if Anne dies, then the property would not be Dan's because he had it as long as Anne was alive. Upon Anne's death, the property would go to Lisa. Now Lisa would have the estate and
In this
remainder.
video, we will discuss the fee simple determinable. A fee simple determinable is an estate or an interest in land that can end automatically. For example, let's say we have Glenda, and Glenda has some land. And we'll say Glenda has a fee simple estate. That means she owns the land and has all the rights one can have in the land. And Glenda has a young friend named Alexa. Glenda gives the land to Alexa with the words, "I convey this land to you and to your heirs so long as the land is not used to sell alcohol." We would now say Alexa has an interest in the land, an estate called a fee simple determinable. The language "I convey this land to you and your heirs" means Alexa has the land, and her fee simple determinable interest gives her almost all possible rights in the land. She could build her own school on the land. Maybe she wants a barn and cows. She could give the land to her friend Boris if she wants. But Alexa or Boris only have an interest in the land so long as the land is not used to sell alcohol. Alexa or Boris's interest in the land will terminate and the land will automatically revert to Glenda if the land is used to sell alcohol. Let's say Alexa does give the land to Boris and Boris gets rid of the barn and the cows. And he starts construction. Boris puts up a nightclub selling alcohol. The estate automatically reverts back to Glenda. Glenda automatically gets her fee simple estate
A leasehold estate is an ownership of a temporary right to hold land or property in which a lessee or a tenant holds rights of real property by some form of title from a lessor or landlord. Although a tenant does hold rights to real property, a leasehold estate is typically considered personal property. Leasehold is a form of land tenure or property tenure where one party buys the right to occupy land or building for a given length of time. As lease is a legal estate, leasehold estate can be bought and sold on the open market. A leasehold thus differs from a freehold or fee simple where the ownership of a property is purchased outright and thereafter held for an indeterminate length of time. and also differs from a tenancy where a property is let rented on a periodic basis such as weekly or monthly, until the end of the lease period, often measured in decades or centuries. A 99-year lease is quite common. The leaseholder has the right to remain in occupation as an assured tenant, paying an agreed rent to the owner. Terms of the agreement are contained in a lease, which has elements of contract and property law intertwined. The term estate for years may occasionally be used. This refers to a leasehold estate for any specific period of time. The word years is misleading. An estate for years is not automatically renewed. Colloquially, lease and leasing are often a formalization of a longer, specific period as compared with the rental that created a tenancy at will, terminable or renewable at the end of a short period.
Tenancy at sufferance is part of what they call leasehold estates. So there's multiple interests you can have in land, from the right to mine something or the right for the whole thing if you own a general warranty deed in fee simple, even to a tenant right? If you're renting something, you have a right to real estate in a limited duration. And this is what we're talking about. Leasehold estates or non-freehold estates are estates in limited duration. They're a term for years. Tenancy at a periodic tenancy, tenancy at will, and tenancy at sufferance. So in this video, we're going to talk about tenancy at sufferance. And tenancy at sufferance arises when a tenant wrongfully remains in possession after the expiration of a lawful tenancy. So this is basically when they overstay their term. So if you have a tenant that says, I'm going to give you the right to farm this land, or I'm going to give you the right to stay in this condo for 12 months, and on month 13, there's no renewed lease, there's no new renewed obligations or contracts, and they're still there, they are now considered a tenancy at sufferance. A tenancy at sufferance, which means these people are basically a trespasser and they've overstayed the term of their lawful tenancy. Now, if the landlord accepts payment, this now turns into a periodic tenancy, which we went over a couple videos back, a periodic tenancy. So basically, when somebody overstays, there is a tenant relationship. They do have an interest in the property, but they're considered a trespasser. And again, you have to be reasonable with any kind of eviction methods. Most states delineate how you can lawfully evict a tenant. But overstaying a lease, overstaying a rental agreement, puts the tenant in the position to become a tenant at sufferance, or creates a tenancy at sufferance.
Here are the benefits of trust: personal privacy, avoiding probate, protecting assets, preserving inheritance, and overall financial wellness, because it's important to protect your family today and through future generations. Now, here are the history of trust. They actually date back to the time of Julius Caesar. Throughout our history, we've seen prominent families use trust to protect their wealth. And of course, we've seen the privacy aspect when it comes to purchasing property, like with Walt Disney when he bought his Orlando property to build his major theme park. So in the words of the great John D. Rockefeller, control everything, own nothing. So why don't more people use trust? Well, there's a lack of knowledge and understanding, and many believe it to be costly and requires expensive attorney's fees. So for that reason, a lot less than 1% of the population actually utilize and understand trust, and that's primarily the wealthy, despite it being easier and more cost-effective than most people would ever understand. The main reason to use trust is to avoid probate and the attorney's fees that go with that, and lawsuits in general, because let's face it, America is a very litigious society, and attorneys everywhere are being paid to sue you for your assets, and there's a few of them. So which property should you put into a trust? Well, actually, we believe anything that's got value should go into a trust, so really all of it, because if you don't own it, they can't take it. Here are the key components of a trust. First, there's the trustee, and the trustee holds legal and equitable title to the real property or personal property, subject to the direction of the beneficiary. Okay, so it's more like a manager, if you want to look at it that way. Whereas the beneficiary is, they retain the power of direction over the trust, the beneficial interest, so to speak, right? So they have the power to choose to delegate that direction to another individual or entity. The goal of the trust is to manage and secure a trust asset. See, the trustee must always put the best interest of the trust and its beneficiaries before his own. The other goal is to protect the interest of the beneficiary, because the primary purpose of a trust is to keep assets private and away from public domain. So the trustee is not to disclose the beneficiary details unless ordered by a court or if directed by the beneficiary. Now, are your assets exposed? Well, let's look at John and Jane Smith. Here they've got their property on public domain along with their mailing address. So having this information out on county record informs the world about the property you own. So you want to avoid this kind of exposure because exposure creates liability. Creditors can use court judgments to seize your personal property if you allow them to do so. The additional ownership liability is comes with having your name attached to properties can create additional lawsuits. Okay, slip and fall, things like that. So now you'll see that John and Jane have taken their name off and they've got their property in the Main Street Land Trust with ABC Corp as the trustee and the P.O. Box mailing address now out there in Safe Now in New York. Okay, so this is the way to avoid unnecessary headaches but still remain in control of your assets. The other benefits of land trust is there's no due on sale clause if you've got a mortgage. So when the deed is transferred for estate planning purposes, the mortgage cannot be accelerated because it's not changing beneficial interest. And for that same reason, there's no sale tax because you're not actually selling the property. So when the property is transferred, sales tax would not be required. Now there's personal property trust, and your vehicle, your car or motor vehicle that you're driving can create sometimes the most liability because you're constantly in motion. So you want to, at least we believe that you want to put your car in a trust to reduce that liability. Okay, so when your car is transferred into a trust, you no longer own it. It's owned by the trust. So if somebody else has your car and has an accident, you are not personally liable. Of course, you're responsible for any damage you create on your own, but not tied to the vehicle. Other items to be placed in trust are anything that has value or could be a potential family dispute with regard to inheritance. So anything like that should be placed into a trust with direction, of course, of the living trust. So now we've got the management and direction, and we use management trust to provide direction and trustee services to land trust, personal property trust, and even living trust. Okay, management trust can also be used to manage other services. Now, living trust really is, we set it up as the beneficiary to all of the other trusts because the living trust provides direction to the entire estate, just like we mentioned earlier. Now, accounting and bookkeeping. Okay, bank accounts can be established in the name of the trust, and the trustee will be responsible for those records. But if you're not familiar with running the books for a company, you may want to consult with an accountant. Now, here's what a trust won't provide. It won't protect you from foreclosure. Okay, so if the property is owned by a land trust or living trust, it won't stop a bank foreclosure because the trust is responsible for the deed, whereas the borrower, whoever had the contract, must still settle the debt or litigate the debt if they have a dispute in court. The trust also won't protect repossession of a vehicle. Okay, if a vehicle is owned by a personal property trust, the debt must be settled or paid according to the terms of any financing agreement or anything like that. Trusts are also not a replacement for insurance. Okay, it won't protect against damage to real property or any kind of theft. So insurance is still a necessity if you want to protect those areas. The living trust provides direction to the estate. Okay, what happens to the home? Who gets the antiques and the fine china? Which son gets the baseball cards? Which daughters get the porcelain dolls? So a living trust is important because it keeps you in control of your family's inheritance, avoiding costly attorney's fees that come with probate. Okay, why pay an attorney to disperse your assets that you worked hard for?
Partnerships represent one of the several common forms of business ownership, and they share many characteristics that a sole proprietorship does, but there's a couple of key differences. Where sole proprietorship involves one person at the helm, one person in charge of making decisions, they essentially are the owner of the business. A partnership means that the business is owned by at least two people. And these owners in a partnership share responsibility. They share responsibility for completing tasks. They share financial resources. They share profits at the very end. And so partnerships are great in a way because you take advantage of a multitude of different skill sets, right? One of the big issues with sole proprietorship was that you were limited to the skills that only you possessed, and you were limited to the financial resources that were only at your disposal. With one of the partnerships, or with a partnership rather, you have the opportunity to leverage a greater variety of skills as well as financial resources. And that's a very significant advantage for partnerships. Okay. Now, we differentiate partnerships into two separate categories for purpose of they share similar characteristics. On one end, we have what we call a general partnership. A general partnership shares responsibility amongst the actual partners, and so they contribute equally usually, although they can have different arrangements, of course, and they also receive typically to somewhat equal amounts. Usually general partnerships have what we call a partnership agreement, although they're not required to. And a partnership agreement really outlines the specific contributions and responsibilities that each partner is going to have. They typically will outline what happens when one of the partners dies. They may outline how do partners split profits. Is it 50-50 or is it some other arrangement? They'll outline who contributes what resources, what financial resources. And so they're very comprehensive. The idea behind the partnership agreement is you want to try and consider as many scenarios as possible, because the goal here is to have something in writing, so if there's ever a disagreement, you can refer to the partnership agreement and use that as a way of clarifying the situation. Unfortunately, if you don't have this, which I mentioned before, you're not required to create one. If you don't have a partnership agreement outlining what to do in specific circumstances, then you're going to have a lot of conflict and it's going to continue to come up. So it's better to have things ironed out in advance for that very reason. Now, in addition to leveraging skills and the financial resources of your partners, general partners also provide you with certain tax advantages. Very similar to a sole proprietorship, a general partnership, the owners and the business are considered to be one. They're the same thing. The business is not separated from the actual owners. And so because of that, it allows you to claim any type of profits as income on your own personal tax returns. And so very similar to a sole proprietorship, we know that the corporate tax rate is usually around 35-40%. And so usually the individual rates are much lower than that. And so you can claim that as your own personal income and save yourself a little bit of money with a lower tax bracket, of course. Now, one of the significant disadvantages of a general partnership is, once again, this idea of unlimited liability. And in fact, unlimited liability is even more of an issue in a general partnership. Because if you recall back to a sole proprietorship, the idea behind unlimited liability is if your business, for whatever reason, was not able to pay its debts or continue to operate and had some debt available, creditors could pursue the owner and their personal assets as a way of fulfilling the debt, is making the debt whole essentially. And the reason for that is the owner and the business are considered to be one person, right? Same thing, the same time you get benefits for taxes obviously provides a disadvantage in related to liability. Now the problem though with the partnership is there are two people, right? And so that means that not only are you responsible for your own decisions, but you're responsible for the decisions of your partner. And so if they go and they bind the business to certain agreements and certain contracts and things, and unfortunately your business can't operate, well, creditors have the opportunity to pick whom. It's called joint and severally liable. And so what happens is creditors are going to pursue the individual that has the most financial resources. And if that ends up being you, Although it's rather unfortunate, they're going to go after the person that has the deepest pockets because they know they can get their money from someone. Maybe your partner doesn't have a great deal of personal assets, but you do. And so chances are I'm going to pursue the person that is most likely to be able to pay me
Anytime
back.
2 or more people run a business together for profit, it's an official partnership. In a partnership, each partner is considered to be one of the business's owners. Partnerships are generally pretty easy to set up. There is no fee or process to form a partnership. You just need a partner and to start making sales. You'll also need a DBA, doing business as, if you want to use a trade name. This usually ranges between $10 and $100 depending on the county your business is located in. And lastly, a partnership agreement is recommended in order to minimize conflict or confusion down the line, but not required. One of the advantages for being in a partnership is that you get to enjoy tax benefits, since the profits and losses of the business pass through to each of your personal income tax returns. Tax responsibilities include, in addition to your personal annual income tax return, you and your partner or partners are responsible for making estimated income and self-employment tax payments once a quarter. Additionally, the partnership itself will need to file an annual partnership return. Another nice aspect of partnerships is that they don't have any ongoing maintenance implications or responsibilities to worry about. Thankfully, partnerships are pretty easy to run because each partner is personally liable for the debts and obligations of the business. In other words, there is absolutely no protection for you should you get into a legal situation. So keep that in mind as you form your business together.
Most people glance at these articles and think, man, must be nice. However, most people don't realize that these extremely large transactions don't usually involve just one individual as a seller or buyer. In fact, only a small percentage of these super large transactions are bought or sold by just 1 or 2 people. Easily over 90+% of these properties are bought and sold by groups, companies, retirement funds, and so forth. So imagine you're looking at a $10 million building which needs a $3 million down payment. Let's say you have a good $1 million of equity to buy the property, but that's obviously not enough. How do you go about getting the rest of the funds without selling everything else that you own? Well, first off, we know that you can't go to the bank and get a loan for both the $2 million difference and the $7 million loan to buy the building. Also, your friends and family don't have enough money for you to borrow. Instead, your real estate broker mentions to you that they know of a few individuals that look for properties just like this, but they don't have enough money to buy their own place as well. At this point, the best chance that you and the other individuals could have in buying this building is by forming a syndication. Syndication is when 2 or more individuals pool their money together in order to buy 1 or more properties. They usually do this by forming an S Corp or C Corp, but most commonly they form an LLC, which I defend in my LLC versus TIC video. Once everyone has their money ready, an attorney will draft a private placement memorandum, or PPM. This is basically a document that states that no one is draining their bank account, they understand the risks involved, and so on and so forth. Once this investment group is formed, the percentage you own is usually equal to the amount of money you put in. For example, let's say you put that same $1 million and 4 other people each put in $500,000, totaling $3 million. Unless otherwise agreed to in writing, you would own 33.3%, or 1/3, and everyone else would own slightly more than 16.6%, which is about 1/6. If this $10 million building generates $1 million net cash flow every year, you would get 1/3 of the proceeds and everyone else receives their 1/6 share. The biggest problem when forming a syndication group is when the what ifs start happening. What if the property triples in value in a few years? What if the biggest anchor tenant goes dark and leaves the building? Who's going to put more money into the group to cover the losses until you find another anchor tenant? What if one person wants out of the syndication group for personal reasons? Who's going to be allowed to buy them out? These are just some of the what ifs that could happen. This is the reason why you have an attorney draft a general outline of the prospect goals called a prospectus. It identifies what type of property you plan on attaining along with many of the common what-if scenarios and solutions outlined beforehand. That way everything is agreed to in writing up front, so disputes are minimized later on. Most of the time this includes the sale of the property as well in a few years. Once the group has the PPM stating that people are not risking their entire life savings and the general goals are outlined, the broker will go out shopping. Once there's a property that has been identified, who makes the decision to make the offer? Beforehand, there will usually be one person along with the broker to make most of the decisions. Again, the reasons for this is to streamline everything so there aren't 5 different opinions when everyone wants the same ultimate goal. The property is then purchased, everyone's money is pulled together, and the returns to each investor are divided as specified in the months and years as they continue on. The great thing about syndication is that you don't have to put all of your own money into one single property. You can spread it out to minimize your risk. It's the same concept as to why people don't put all of their 401ks or investment money into one single stock. They put it into multiple stocks. So along with spreading your risk out so it's not all in one project, you're also able to buy some of the sizable, stable real estate properties most individual investors can
Investors can pool their resources to buy a property together and share the cash flow, equity, and appreciation at the end of the term. In this joint venture program, we use our platform to link you with one or more investors who qualify to buy a property together with you. As shared property owners, all investors contribute to the down payment and enjoy the equity and appreciation selecting the right property to meet the desired return on investment in a given time frame. Developing a budget, projections, and cash requirements. Performing due diligence for the investment. Working with the lenders, real estate agents, home inspectors, lawyers, contractors, etc. Performing and/or oversee repairs and renovations. Advertising and showing the property, screening and selecting tenants, preparing leases, collecting deposits, etc. Bookkeeping and banking for the investment and provide updates to the investor. At the end of the term, property is sold at market price, and profits from the equity, appreciation, and surplus rents are shared proportionately among investors.
A corporation is a legal entity that is separate and distinct from its owners. Corporations enjoy most of the rights and responsibilities that an individual possesses. That is, a corporation has the right to enter into contracts, loan and borrow money, sue and be sued, hire employees, own assets, and pay taxes. The most important aspect of a corporation is limited liability. That is, shareholders have the right to participate in the profits through dividends and/or the appreciation of stock, but are not held personally liable for the company's debts. A corporate structure is perhaps the most advantageous way to start a business because the corporation exists as a separate entity. In general, a corporation has all the legal rights of an individual except for the right to vote and certain other limitations. Corporations are given the right to exist by the state that issues their charter. If you incorporate in one state to take advantage of liberal corporate laws, but do business in another state, you'll have to file for qualification in the state in which you wish to operate the business. There's usually a fee that must be paid to qualify to do business in a state. What sets the corporation apart from all other types of businesses is that a corporation is an independent legal entity, separate from the people who own, control, and manage it. In other words, corporation and tax laws view the corporation as a legal person that can enter into contracts, incur debts, and pay taxes apart from its owners. Other important characteristics also result from the corporation's separate existence. A corporation does not dissolve when its owners or shareholders change or die.
Recently, there's been a lot of talk about the role of corporations in our economy, but no one takes the time to explain exactly how they work or the benefits they provide. So let's give it a try. Corporations are designed to make a profit while delivering value to their shareholders, and by doing so, they drive economic growth and all the good things that come with it. And as corporations grow, many individuals invest directly or indirectly through mutual, pension, and retirement plans. These stockholders provide seed money or capital for corporations to grow. And in doing so, they create economic growth and reward investors with the opportunity to profit. In this video, we'll start with the basics of corporate structure. But be sure to check out later episodes where we'll dive into some of the specifics. Now, when you think about how a company runs, your first instinct may be to compare it to something like a school board or a homeowners association, or even Congress, where decisions are made by a simple majority vote. But corporations are more complex. In fact, there are 3 principal groups that govern corporations. They are the management, board of directors, and shareholders. Now, the relationship and responsibilities of these 3 groups are defined primarily by state law and a corporation's own charter and bylaws. That means each corporation is a little different, but all have government oversight. The management is made up of all those people with acronyms like CEO and CFO. Their responsibility is running the day-to-day operations of the company. Most importantly, management identifies and manages corporate risks. Now, the board of directors' responsibility is overseeing the strategy and performance of these guys and gals, the management. Within the board are various committees designed to tackle specific issues, such as audits, compensation, or corporate governance. Committees recommend policy for approval by the entire board. But we'll talk about this more in future episodes when we explain the inner workings of boards. The board of directors' main responsibility is to make decisions in the best interest of the corporation's shareholders, the people who voluntarily invest by buying stock. That's why they are commonly referred to as owners. Shareholders' piece of power is the right to elect these directors. They also approve mergers and acquisitions. And that's the structure of the corporation, employing millions of people in all sectors of the economy, providing health insurance and retirement plans, providing investment opportunities for all generations, and providing innovative products and services that affect every aspect of daily life.
We continue at the bottom of page 62, the bottom third of the page, and we look at cooperatives and condominiums. Now, cooperatives and condos are found all throughout New York State. There's many more cooperatives in the New York City area than any other part of New York State. I think you'll find it useful if you can pull out an index card and list all the attributes of a co-op as we go through it. Also, pull out another index card where you can list all the common attributes of a condominium as well. And here's the reason why. You really want to make sure that whatever you're listing or selling, that you understand what kind of legal setup it is. Just because we say that co-ops are found mostly in downstate New York, there's a co-op building right on Delaware Avenue in Buffalo. If you go down to Ellicottville, there's some co-op units that are right near Holiday Valley. So just don't think because we say co-ops, it's got to be a New York City thing. In the second last paragraph of page 62 at the bottom, under the typical co-op arrangement, title to the land and building is held by a corporation. So that's the first thing you can list under your index card for a co-op. It's always held, title to the property is always held by the corporation. There's no option other than that. The other thing that's common with a co-op, which we'll see, is that a proprietary lease is what a person gets with a co-op. With a condominium, you get a deed. So that's a big difference. You cannot get a deed to a co-op. The equivalent would be a proprietary lease. So as we continue here, tenants buy stock in the corporation and they receive a proprietary lease to their apartment. As stockholders, they exercise control over the administration of the building through an elected board of directors. Tenants contribute monthly fees to cover maintenance costs, the corporation's property taxes, and the overall mortgage on the building. Statements are provided for tenants to use to determine what portion of their fees are or may be deductible for income tax purposes. So whether you own a condo or you have a proprietary lease to a co-op, you do get to deduct your property taxes based on current tax law. Last paragraph of page 62. The corporation, however, is financially vulnerable. If other tenants cannot pay their mortgage charges, the owner or occupant can lose out in the event of a forced sale of the property. So it's kind of a big deal because if you've got co-op owners who are not paying their fair share as per the agreement and in their proprietary lease, then that becomes a problem for the entire balance of the owners in that building. You're going to have to pick up the slack for everyone else who's having an issue, or for anyone that's having an issue, essentially. The same thing happens with condo owners. If there's a condo owner who stops making their payments as far as their monthly homeowner association fees, then all the other condo owners will have to pay an additional surcharge based on what the homeowner association comes up with to make up the difference. Now, the thing that's a little different between a condo and a co-op is that if someone's not making their monthly payments, there's probably a chance that they're going to be foreclosed on either by the homeowner association for non-payment of dues, or they're probably having other financial problems and the bank is in the process of foreclosing on them at some point soon as well. And this is the biggest risk you run into with co-op or condo ownership. Let's look at the top of page 63. The owner of each condo unit gets a fee simple title or fee simple estate to their dwelling. They also have an indistinguishable stated percentage of other parts of the building and land. This is what we call the common elements. So the only definable space that a condo owner owns is the airspace between their four walls and ceiling and floor. Other than that, they own an indistinguishable portion of common areas. So that would be hallways, service walks, parking lots, driveways, anything on the outside of their unit, they own an indistinguishable percentage of, and it's usually based on how much square footage they have. If you could look at the third line of page 63, the condo owners hold the common elements as tenants in common with no right to partition. So you should know that for test purposes. Condo owners hold the common elements as tenants in common. Next paragraph. The condominium form of ownership may physically look like an apartment, which would be found in an apartment complex or building. They could be freestanding and detached like a ranch-style home. Sometimes we call that a patio home. High-rise buildings or even a townhouse design. So you can't look at a building and say, okay, that's a condo. You just can't. The only way to know for sure is to get your hands on the deed and see what it says. Typically, a condominium, this is the majority of the time, a condominium will not have a lot size on the tax bill. So if you look at a tax bill, you typically will not see a lot size in 99% of the cases. That's another item that you can add to your index card as far as condominium attributes, or the key attributes of a condominium, is that you're not going to find a lot size. It'll be 0 by 0. Because when we look at a tax bill, on the tax bill it'll have frontage and depth of a typical detached home. So the typical homes you drive by, Cheektowaga, Lancaster, Amherst, anywhere in the area, it'll say something like 80 by 120. That 80 means how much feet in road frontage by how much feet in depth. So with a condo, it'll be 0 by 0. Also, if you look at the SBL number, that's the section, block, and lot number, that's the number on the tax bill. That's something like, for example, it would be 338.2-3-1. So that first number, that first series of numbers is the section number, and then the number that follows the dash is the block number, and then the final set of numbers is what we call the lot number. Okay, so that's where we get section, block, and lot from. I share that information with you because with a condominium, the lot number will end with a kind of a weird number with an extra, like a bunch of zeros. They might have like a slash there, so it'll be like, 338.0-3-1, and then a condo would have, after the -1, it would have, so it'd be like -1.000332. And the 332 at the end of that SBL number is usually the unit number of the condominium. Okay? So you should try to write down some of that information on your key attributes of a condominium. For the most part, a property owner generally knows what they live in, especially if they've been making their HOA or homeowner association fees every month. They're going to be pretty familiar with the concept that they're living in a condo. And they're also given a prospectus, or what we call CC&Rs. CC&Rs is the thick paperwork that they get that's like a little book. It's like in a binder. And they get it when they first buy the property, and then they get it from every subsequent sale of the property. They get the one from the previous owner, and it outlines all the rules of the association as far as, can they have pets, and what's the size of the pets, and is there parking restrictions as far as you can't park your tractor trailer overnight, or you can't have for sale signs when you sell the property in the front. There's a lot of restrictions because that's the way it is. Condos are like that, co-ops are like that. Any kind of shared housing has a lot of different rules in place that you don't normally see with typical detached fee simple estates. In the middle of that second paragraph on page 63, we bring to your attention that a townhouse is not a legal form of ownership. It's a style or design. So if you want to pull out another index card, I would write on there key attributes of a townhouse. And the key attributes of a townhouse include they get a deed, so you will have a deed. You should write that down. So a townhouse will definitely have a deed. When you look at the tax bill will have a very narrow lot size. So typically you'll have a lot size of maybe 16 or 18 feet by 120. So that's a real, like, bells and whistles should go off when you see that you're probably looking at a townhouse. And you always share a common wall when you have a townhouse. You don't always share a common wall with a condominium, because with a condominium, if you're in a patio home community, like we've had them in Western New York for about 20 years now, with a condominium that's set up as a patio home, you don't share a common wall. That's what we call detached housing. So you can't go by that strictly, but you always have a common wall where you share a common wall. That really separates both units. It's kind of the equivalent of taking a duplex, cutting it in half, and one side is a townhouse and the other side's a townhouse. Townhouse doesn't have to be 2-story. It can be a 1-story. There's townhomes that are in Tonawanda off of Sheridan Drive, for example. There's a lot of townhomes in the town of Amherst, Cheektowaga, Lancaster. They're everywhere. Tons of them in the city of Buffalo too. And if you remember a moment ago, I had mentioned that a townhouse does not have to have a homeowners association to make it a townhouse. So I would write that on my index card under the key attributes of a townhouse. You do not have to have a homeowners association or an HOA fee to make it a townhouse. But they're absolutely mandatory with a condo. You should really know that for test purposes. A couple other key attributes with a townhouse that's really important is that you own your front yard, you own your backyard. You don't have that with a condominium. You might have the right to use it, but you don't own it. It's an indistinguishable portion of that you own, but you don't really own anything outside with a condo. With a townhouse, you own your front yard, you own your backyard, you own the land that your property sits on. So the basement, you'll actually own your own basement. With a condominium, you don't own your own basement. If you happen to have a basement, you don't own it. You may have a right to use it. You may have a right to use a storage section in the basement, depending how your property is set up. But with a townhouse, you do own your basement, the foundation that supports your superstructure, the skeleton framing of the home. And you own everything up to the sky as well. With a condo, you don't own anything outside of your roof. You own up to your ceiling with a condo, but not with a townhouse. So please make sure to write that down. This is important stuff. That second paragraph is wrapped up by talking about more examples of what common elements are included. So, we discussed most of these already, but you should also know there could be tennis courts and other recreational facilities that go along with a condominium that you don't have typically with single-family detached homes, and even with townhouses, you may not have these extra things that are included. So when you list a property that's considered a condominium, you want to ask the property owner, what do you get as far as benefits from your homeowner association fee? Does it include a use of the swimming pool or a rec center, or does it include, it could also include use of a garage or storage facility. So this is all things you have to find out. You want to find out, does it include any utilities? Like it could include water, it could include cable too. In the third paragraph, we talk about the fact that condo ownership is also popular for professional or medical office buildings around the state, in commercial areas like where the school's located. You know, technically, you may not know this, but this whole strip that we're in, this is commercial condos. So we own our suite, you know, and then the people next door own theirs, and the ones on the end, they own theirs. And it's a real common type of ownership for businesses. Something else that's covered in this paragraph is the fact that condo owners generally pay less in property taxes compared to non-condo ownership. And the reason why is because the association fees that we pay cover some of the expenses that the town would not have to pay. So you could save up to 30%, in some cases even more. It's 40-45% on what would normally be paid for a property that's set up as condo status like we are. There's property owners less than a couple miles away from here who live in properties that are easily worth $500,000 to $600,000 or more, and they pay less in taxes than some $100,000 ranches in the town of Cheektowaga, because they're set up as a condo, but you would never know it. You drive by and they look like single-family detached homes, and they're right near the country club, not too far from here, going up Youngs Road and in that general area towards Sheridan Drive. It's kind of mind-blowing, like how much money the property owners save because they're set up as a condo, not as a non-condo status. In the fourth paragraph of page 63, the owner of a condo unit receives a separate tax bill and can mortgage the individual unit. So that's another key attribute if you don't already have that written down. Under a condo, you have a separate tax bill and you can mortgage your individual unit. Co-ops don't get a separate tax bill. So I would write that down as well. So a co-op owner gets a statement from the corporation which indicates how much they can deduct for property taxes each year. There are mortgages available for co-op owners, but they're not the traditional type. It's a very select group of lenders that lend money for co-ops. A lot of co-ops right now that you can't even get a mortgage on them. It's strictly you pay cash or you can't even move into that unit, especially down in New York City. It's very common that you have to pay cash, and that's part of the qualifications, because you have to go before the board and get an approval. They actually sit there and interview you like it's a job, interview, and it's a real stressful experience from what we hear. In a little later on in the program, when we have a whole section just on condominium ownership, it's like towards the end of the program, you're gonna watch interviews of what people go through, and it's kind of mind-blowing how it's handled, and it's a lot of stress. In the middle of page 63, the condominium property is administered by an association of unit owners. It may manage the property on its own or engage a professional property manager. So that's another question you want to ask. Whenever you list a condo, you want to find out who is the property manager for the building, and you want to get their name and phone number. If it's anything other than a property manager, you get that information from the owner as well. So the default in the payment of taxes, homeowner association fees, or the mortgage loan by one unit owner can result in a foreclosure sale of that unit, but it won't affect the ownership of the neighboring owners, because remember, with a condominium, each person gets their own deed. Each unit is separate. It's not like a co-op where each person just gets a proprietary lease and everything is owned by the corporation. Because with a co-op, that that proprietary lease that you get, matter of fact, hopefully you have that written down under the key attributes of a co-op. The key attributes of a co-op includes the fact that you get a proprietary lease, and that's the equivalent of getting shares in the corporation, like shares of stock that you would own in any kind of corporation, especially outside of what we think of when it comes to real estate. In the middle of that paragraph, when an agent lists or sells a condo, he or she should obtain a number of items from that client, including the name and contact information for the management company. The buyer's real estate appraiser and bank will also need that information. So it's very important that you make the process as smooth as possible and get this information up front when you're listing the property. Another common question that the appraiser, who represents the lender, they're going to want to know how many units are in that particular phase, what percentage of units are rented, and how many are for sale as well. And of course, the monthly association that we mentioned earlier. So these are questions that the bank appraiser will ask. And, like literally, this still applies. I'm a certified appraiser, and I actually, I go out and I do these appraisals, and these are questions we have to ask. And if you can provide that information to the appraiser when they call up after you're successful in getting the property sold, it just helps the whole process go smoother. You don't want to look like you don't know what you're doing. You've got the information right here. So make sure you add that to your list to find out how many units are total in that project, how many are rented, and how many are currently for sale. Now next we look at the fourth paragraph from the bottom, and all of that covers townhouses. And we basically gave you all that earlier, so just make yourself a note to read that on your own. In the second last paragraph of page 63, we talk about timeshares. A timeshare is a type of ownership that's typically found in resort areas. So we don't have a lot of resort areas in Western New York. The closest thing we have is Ellicottville again. So you might find some down there. I don't personally know of any down there, but that's where I would guess we'd have some. So for test purposes, if you see a question about timeshares, the answer will involve resort. You need to know that when you hear resort, think of timeshare. When you hear timeshare, think of resort. And a timeshare is what we call a fractional type of ownership. And the deed, you actually get a deed when you get a timeshare, and it breaks it down, your ownership period, into days or months. Some time frame will be noted in the deed. We don't see that with any other types of deeds except for timeshares. I'd like you to look at the last sentence of that paragraph. The seller of a timeshare has to offer buyers an opportunity to cancel their purchase for a period of 7 business days after they have a signed contract of sale. You should know that for test purposes, that you have 7 business days to cancel your contract for a timeshare in New York State. And in some states, if you go to Florida, because we also do licensing for Florida, there's like a whole separate license you get when you're involved with timeshare sales, because it's such a big chunk of their market, and there's so much resort area down there. That's something to be aware of. In the final paragraph of page 63, we talk about the term encumbrance. An encumbrance is a right or interest held by a party who is not the owner of the property. Encumbrances may be divided into 2 categories: financial claims against the real estate, so we call those liens, and restrictions, or what we call usage encumbrances. And they can include encroachments as well as easements. We continue on page 64 at the top. Financial claims are liens against the real estate. Restrictions, easements, and encroachments are usage encumbrances. Next paragraph, a financial claim against real estate that provides security for a debt or obligation of the property owner is known as a lien. If the claim is not paid, the creditor or lien holder can ask the court to order that the real estate be sold for full or partial satisfaction of the debt. A process known as foreclosure of the lien is what occurs if that happens. Then we see the term in rem foreclosure. a proceeding that's initiated against the real estate directly, as distinguished from a proceeding against the person. So please know that for test purposes. It's a pretty popular question on the state and the school exam. So when you hear in rem on one side of your index card, put in rem foreclosure, and on the reverse side you want to put a proceeding against the real estate as compared to being against the person who owns the real estate. Then the term lis pendens is next. So when you hear lis pendens on your index card, again, you want to write lis pendens on one side, and then on the reverse side you want to put notice that a lien is forthcoming. So let's read that paragraph together. A legal process that gives public notice that a lien is forthcoming against a property. So this lis pendens can establish a priority for the lien that may follow at a later date, providing that the court awards a judgment. So lis pendens can be particularly helpful to potential purchasers of real estate, lending institutions, and lien holders. That's why prior to closing, like literally when you're at the courthouse and your attorney's in the process of trying to get your mortgage closed and you're in your house closed, they always do that one last check to see if there's any other liens that are coming against that property so that it can be caught before you close. That's why they do that. In the middle of 64, we talk about voluntary liens and involuntary liens. So a voluntary lien is created by the owner's action. When you go and you apply for a mortgage and all that paperwork that you sign, and we have a whole chapter that's dedicated to mortgages and finance, when you do that, that's considered voluntary. You're willfully doing that. You know that you're going to be creating a lien as a result of applying for a mortgage. That's the way it is. But an involuntary lien is created by law. So when you don't pay your property taxes, if you don't pay your water bill, those are liens that are considered involuntary because it happens as a result of an action that you caused by not making payments as agreed to. In the next section, we talk about general and specific liens. General liens typically affect all the property of a debtor, both real and personal in nature. These include judgments, estates, and inheritance taxes, etc. Specific liens in the next paragraph, in contrast, are secured by a specific parcel or tract of real estate and affect only that particular property. So when you get a mortgage on your house, that's a specific lien. When you don't pay your taxes on a particular house, that's a specific lien on that house. It's not going to affect other houses that you own. In the next section, please know that real estate taxes always have a first claim against the property. So we bring that to your attention because a mortgage, a lot of people think that the first mortgage is the first lien on the house. But in actuality, the real estate taxes are the first lien on the house. At the bottom of page 64, judgments are court orders to pay a debt, such as an unpaid bill. They're automatically docketed or filed in the county clerk's office and become liens against all real property in that county. And that's why if you can get familiar with doing searches online, you can actually go on to erie.gov, so that's www.erie.gov. And then you click on the county clerk's office, so county clerk's office, and then look at online records. You can actually research a property when you're listing it or selling it. And I recommend that you even go on and look at yourself. Look at what is listed in the public records under your name for at least Erie County if you live and work in Erie County. Every county will have their own records online if they happen to have them online. Some of the rural counties, like Chautauqua and Cattaraugus, they didn't have their records online for the longest time. So you may have to do it the old-fashioned way and actually go to to wherever the county seat is in the county where you want to get this information from. Next, we look at page 65. On page 65, we talk about mechanic liens. So mechanic liens are placed against a specific property by workers or suppliers that have not been paid for labor or materials used in construction or repairs on a home. So if a lien is not satisfied, which means paid off or discharged, it will remain with the real estate. Liens attached to the property. So if you hire a plumber to come to your property and you don't pay the plumber for work that's been done, they can file a mechanics lien, and we provide that information as far as deadlines at the bottom of page 65. But let's continue, third paragraph. If the purchaser of real property agreed, an owner could sell a parcel of real estate even though it was encumbered by a lien. The lien, however, would remain with the property because liens and other encumbrances run with the land, and they will bind future and consecutive owners if steps are not taken to clear them up. Now, unfortunately, you'll see a little later on in the program that real estate commissions don't count as a mechanics lien. So we have to file an affidavit of entitlement. But we'll talk about that in a little bit. So in the middle of page 65, we talk about the priority of liens. Number 1, real estate property tax liens. That's the first. Number 2, a special assessments. And we define that in the next section below. Number 3, then a first mortgage, then a second mortgage, respectively. So second mortgages would be home equity loans and home improvement loans. And then number 4, as far as a priority of liens in real estate, would be all other outstanding liens in the order of their priority based on the date of recording. So let's look at the definition of special assessments. An assessment that's made against a property to pay for public improvements that were made in that particular neighborhood or area. Special assessments do not typically last forever. The exact amount of the special assessment can be found on the property tax bill or by contacting the local assessor's office. But the big problem with special assessments is it doesn't say on the tax bill that this is a special assessment. It's some kind of a ridiculous code that, like, you look at it, it's got XYZZ324. Like, who knows what that means? So you literally have to ask the assessor's office or the tax office in that town, are there any special assessments on my property? And I'll tell you, almost every class, every year, we have at least 2 or 3 people that we've told this to, and they come back later and say, you know what? I did what you suggested. I checked with the town, and they said that I actually did have a special assessment for sidewalks that were improved 22 years ago. And it's like they're already old again. So, and that's what a special assessment is for. A special assessment are for improvements that have been made to the neighborhood. So maybe new curbs, maybe water lines that were replaced. Sidewalks are a popular one. Lighting is also a popular one. But if you don't check whenever you buy a home in a neighborhood, including if you've already been living there for a number of years, they could be charging you for something that's already been paid for a number of years. So why throw that money out the window and keep paying an extra? It could be $15, $25 a year. Why pay that every year if you don't have to? Then we talk about subordination agreements. Subordination agreements are written agreements between lien holders to change the priority of the lien or priority of the mortgage. So that's a great index card moment right now. On one side of your index card, you put down subordination agreement, and then on the reverse side, you put down change in the priority of a lien, a mortgage, a judgment. And you might say to yourself, who would even agree to do something like this and subordinate? And because if you're first lien holder, why would you want to say, okay, sure, I'll be second lien holder? Like, you just increased your risk. But it actually happens more often than you think, because what happens is when people refinance their mortgage and they have a home equity loan in place, they actually have, if the bank is changing, they have to get permission from that second lien holder saying that, okay, you promised to stay as a second lien holder, because for that split second that we pay off the first mortgage and replace it with a new first mortgage, we want to be sure that you don't try to move up to first lien place. So that's a perfect example of when we do a subordination agreement. So please know for test purposes what that means. Then we talk about mortgage liens in the next paragraph. So make sure you note that you should read that. Again, we're trying not to read every single thing to you. If you have any questions, feel free to talk about that. And then I want to look at mechanics liens at the bottom of 65. A mechanics lien covers a situation in which an owner has not paid for work that was done on the property. It could be by a general contractor, or it could be by an electrician, plumber, you name it. So, a claim for a mechanics lien must be filed within 4 months of the completion of the work on a single-family dwelling and 8 months for any other structures. A mechanics lien is valid for 1 year and may be renewed. So that's just another FYI for you. We don't hear about this showing up on the state exam a lot, but that doesn't mean that it might not show up. You just never know. There's 3,500 questions as far as the data bank comes from for exam questions, and you just don't know which ones are going to be on the exam you take. Top of page 66, we have a please note item there that we'd like you to read through. There's an opportunity, there's only one little tiny opportunity for you to be able to file a mechanics lien, and that's if you're involved with a commercial property and you negotiate a long-term lease, but long-term has to be at least 3 years or longer, and it also has to be structured based on a written commission agreement. So this really only applies to people that are involved with commercial property, or if you're a residential agent and you happen to have an opportunity to do this, this is what this is all about. So just keep it in the back of your mind in case you ever run across this. Very rare you're going to have a state exam question on this. This information is really included so that just in case you happen to have that opportunity, maybe you'll remember vaguely that, oh, hey, we covered this in class, and it's a way that I can ensure that I get paid my commission, and if not, at least I have a chance of getting a lien against a property. Because there's times that you might be dealing with someone who wants to rent commercial property, and you say to them, oh, so how many years would you like me to write the lease up for? And, if they say, 2 or 3 years, then hopefully you remember in the back of your mind, hey, if I go 3 years or more, then at least I know I can get paid my commission by filing a lien, a mechanics lien against them for non-payment if I meet this criteria. So that's why we tell you your textbook is something that you're going to want to keep around for many, many years to come. You never know when there's going to be something that you just happen to remember that could be useful and benefit you in such a way. In the next paragraph, we look at the affidavit of entitlement, which you heard me talk about a few minutes ago. So a real estate broker cannot file a mechanics lien, but you can file an affidavit of entitlement that lets the world know that a commission was not paid. And that's all it does. It doesn't put what we call a cloud on the title. It strictly says, hello world, a commission wasn't paid. And unfortunately, nobody really cares. But this is about the most you can do as a real estate broker. And I'm happy to tell you that most commissions are paid. It's not like it's a 50-50 crapshoot that you're going to get paid. You really do get paid most of the time. So that's a good thing. Let's look at judgments in the middle of the page 66. A judgment is the decree issued by a court. When the decree provides for money to be awarded to the creditor, it is sometimes referred to as a money judgment. In contrast to a mortgage, where a specific piece of real estate is given as security, in a judgment, real estate was never given as security for the debt. So please know for test purposes that judgments are good for 10 years and may be renewed for an additional 10 years. In the next paragraph, a judgment becomes a general involuntary lien on all real property in the county owned by the debtor when it's filed in a county clerk's office. And make sure you read the next paragraph on your own. Not usually too much testable items come from there, but I want to bring to your attention the last paragraph of page 66, a satisfaction of judgment. So when a judgment is satisfied or paid off, the debtor should request a legal document known as a satisfaction of judgment. It's also called a satisfaction piece. This is an important document that should be appropriately filed with the county clerk's office in which a judgment was filed. It's also a way to show that the judgment was cleared. On page 67, that's a sample of what a discharge of mortgage looks like. So when you pay a mortgage off, either when you pay it off after X number of years or you refinance, they pay off that other mortgage with they replace it with a new mortgage. That discharge of mortgage lets the world know that that debt has been paid. And if you go to County Hall, because you can't do this online, you have to have a special account to be able to see the actual physical document. When you go on erie.gov, you can't see the physical documents. You can only see typed text that refers to the documents, and you can figure out from the codes what different things mean, and they give you abbreviations and templates to understand all of that. But to see the actual physical deeds and the discharge of mortgages and judgments against any property owner, that's all public record. You can see that downtown, and all you've got to do is know the address that you're looking up, and you can find out anything against any property. It's all public information. We look at page 68 now, and we look at other usage encumbrances. So the first one we see is deed restriction. An imposed restriction placed in a deed for the purpose of limiting or restricting the way land may be used. Typical deed restrictions include prohibition of fences, tree cutting, in-ground pools, etc. So owners can place deed restrictions at time of sale. So we call deed restrictions private restrictions that you can place on property as an owner or developer. Then we see the term easement, and that's just a basic general definition for an easement. A right typically created by a written agreement that may be exercised or acquired by the public or individuals to use the land for another for a special purpose. You really got to know what an easement is, because that shows up quite frequently on a state exam. So an easement is a right that can be exercised by the public or individuals to use the land of another for a special purpose. Then we have the term easement in gross, the mere right to use the land of another. The most common example of an easement in gross is when a utility company gets this kind of easement so that they can run power lines and anything else, cables and whatever else they need to run along your property in order to provide services to a neighborhood or a community. Next, we look at easement appurtenant. This is a permanent type of easement, so I would underline or highlight permanent. That's really an important trigger word, because when you're talking about easements and the word permanent is in it, the answer will usually be an easement appurtenant. So this permanent type of easement benefits neighboring or adjoining parcels of real estate. That's the other part of the trigger word. It benefits a neighboring or adjoining parcel of real estate. Next, we look at easement by necessity. If a parcel of real estate can only be accessed through another person's property, maybe because it's landlocked, then the owner can acquire an easement by necessity to gain access to their land. Then we see the definition of party wall, and we talked about party wall when we were discussing townhouses. So if two buildings share a common wall, which is built right on the property's boundary line, each owner will have an easement on the opposite side's wall, because a lot of times there's electricity, there's plumbing, things that can run between both properties. So if you need to gain access in order to service the property, it's a mandatory thing. There's no way to do it without having an easement, and each party gets the same easement to the other side for any kind of repairs to be able to have access. Then we look at an easement by prescription. In New York, the law allows, under specific circumstances, that a person be able to acquire a permanent right to use another person's property. So what we say is the open, notorious use for a period of 10 years or more can create an easement by prescription. The process known as tacking, in the next section, the process known as tacking allows consecutive owners to accumulate the requisite 10-year usage. So, and this actually happened to me many, many years ago. I had a property in the town of Boston, and the front of it was, I believe it was on Eddy Road in the town of Boston or Colden. It was right on the border there. and the front of it was on Eddy Road, and the back of it backed up to a property that the frontage was on the opposite road, and the people had used the back 2 acres of this 9 or 12 acre parcel for years and years, like I'm talking about generations. And when it was finally sold, the surveyor determined that this was being used. It affected the whole transaction. We literally had to renegotiate, but the people really wanted the front parcel because it overlooked, you could see the whole Toronto skyline. And it was, but it was interesting because it was literally like I had been in real estate for a good 5 to 6 years at that point, and all of a sudden I was hit by this easement by prescription, never thinking that this would happen. I thought it was just one of those oddball things, and it happened. So, if you have a bunch of land that you own, especially in a rural area, you got to make sure that there's no one using that in a way that if they can use it for 10 years, they just acquired property and you're stuck. There's nothing you can do about it. They'll have the permanent right to use that property forever, and you're still paying taxes on it. How about that? So they get to use it, you pay taxes, and then also you have the liability as a property owner. So this is a very real thing. Then we see the term encroachment. When a building or some part of it or any obstruction intrudes upon or invades an adjacent property owner, this is called an encroachment. And the most common encroachment we have in real estate is when they build a shed or they build a garage or a second garage, and they're not careful with the survey, and they build it onto your property. So it actually encroaches, just like the football definition of encroachment. So this is why banks require that we get a survey done. Every time you get a mortgage on a house, they want to make sure that no one either put the fence on the wrong property line, that they didn't build a patio, poor patio, that it went over, over their property onto yours, the one that's being financed. So encroachments are very real, and they happen quite a bit. At the bottom of 68, we see the term license. A license is a privilege to enter the land of another for a specific purpose. The main characteristic of a license is that permission may be withdrawn at any time. So we say that a license isn't an official easement, because easements aren't that easy to just cancel. So it's a process to go through. And it goes beyond the realm of the course for us to get into all the details. You need to see a lawyer. You need to go to court. It's a process. But now a license is literally simple permission. We also say that a license is a privilege given by a landowner, period. Let's look at the top of page 69. We talk about deeds. Deeds are prepared by lawyers, and when executed and delivered, they convey title to real property. Sometimes a deed only transfers part of an owner's interest. One of the essential elements of a deed is an adequate description of the real estate being conveyed. Deeds typically describe the land in an unimproved status. In other words, it doesn't consider that there's already a house on there. It talks about just like it's vacant land. In the next paragraph, a legal description should include all boundary lines of the property, including dimensions and angles, street address, city or township, county, and state. The real estate tax account number is often included to further support the legal description. In that box, we see that there's 3 methods of land description: meets and bounds, government survey, and plat map references. In New York, a legal description for real estate may use any combination of descriptive methods. We'll have some video components that further reinforce this at the end of this section. Please know the definition of a meets and bounds description. A meets and bounds description uses the boundaries and the measurements of the land in question. It starts at a definite point or place of beginning. So POB, point or place of beginning. If you see that in a question, that's your trigger word to know that we're defining a meets and bounds description. So please put that on the back of one of your index cards. POB equals meets and bounds description. Has to be part of it. They proceed in a clockwise fashion around the boundaries of the tract by reference to measurements and directions. So in a meets and bounds description, we say that it always ends at the point where it began, the POB. Please know the definition of monument. I would put that on an index card too. In a meets and bounds description, monuments, and here's the part to know, are fixed objects used to establish boundaries. So on one side of your index card, put fixed objects used to establish boundaries, and then on the reverse side, put down monuments. And then we give you some examples of them. Then we look down at the government survey system. Just give that a cursory review. And then I want to look at the second last paragraph of page 69, plat of subdivision. This third method of land description is by lot and map number, referring to a plat of subdivision. It's filed in the clerk's office of the county where the land is located. And the recorded plat of subdivision method is also known as the block and lot method. So that you should know for test purposes, and that's what we actually use most in the western parts of New York State. So the first step in subdividing land is the preparation of a plat map by a state certified licensed engineer, or typically it's a surveyor. Please read the balance of that paragraph at the bottom of 69 on your own. Again, you really want to make sure you touch every page of this book before you take any school or state exam. On page 70, we look at surveys, air lots, and elevations. So a licensed surveyor is trained and authorized to locate a given parcel of land. So a survey sets forth the legal description of the property. Please don't forget that a survey is always required when you get a new mortgage on a property. Typically, a refinance won't require a new mortgage, but they do have to sign paperwork. The mortgagor, who's the borrower, so the mortgagor is the borrower. You'll see that when we talk about finance. They typically have to sign a form saying that there's been no change, they've made no modifications to the property, and then that's how they get out of having to do a new survey. In the next paragraph, the owner of a parcel of land can subdivide the air above the land into air lots. It typically doesn't happen in Western New York, but this does become an issue in New York City, especially in Midtown Manhattan, where air lots are worth a ton of money. So this type of description is found in titles to skyscrapers and other tall buildings. Condominiums may also be surveyed based on a description where the surveyor describes each condo unit by reference to the elevation of the floors and ceilings above the city datum. So then we describe datum in the next paragraph. You do want to know that for test purposes. A point, line, or surface from which elevations are measured or indicated is a datum. So that's a memorizing item. You want to put that on an index card. Datum on one side, and then point, line, or surface from which elevations are measured. If you memorize just that minimally, you'll be good to go. There's no way to ask a question about datums without using that phrase, point, line, or surface from which elevations are measured. In the next paragraph, we see benchmarks. Another term you want to memorize, and don't confuse it with a datum. So on one side of your index card, put down benchmark, and then you want to put on the other side permanent reference points. If that's all you need, and you're good to go for another one. Because most real estate agents, you won't talk about datums and benchmarks. It is just not part of what we do as a real estate agent. Unless you're really out in a rural area and you're just doing a ton of vacant land, then you might talk about it, especially if you stumble upon it while you're out in the field. But benchmarks aid surveyors and their permanent reference points, and they're found all throughout the U.S. Then we talk about the characteristics of deeds at the bottom half of page 70. Make sure to read through this on your own, but I want to highlight a couple important things. For example, deeds have to be in writing to be valid. So the owner who grants or sells or gives the land is called a grantor. So the grantor is the person who's selling the property. The new owner is called a grantee. So the buyer is called a grantee. You should know that as well. A deed is always signed by the grantor or some other legally authorized individual. So until the buyer sells the property, they're not going to sign the deed. Only when they sell the property in the future will they be listed on the deed as a grantor. The 11 elements for requirements of a valid deed are at the bottom. give that a read through. The one thing I want to mention about the bullet points is that a habendum clause, so the habendum clause always begins with the words to have and to hold. That's a state exam favorite question. So habendum clause, you put that on the front of your index card, and on the reverse side, to have and to hold. So that defines ownership. The habendum clause defines ownership in a deed. The second last bullet point, we talk about acknowledgement. So the deed has to be acknowledged before a notary public or a recorder of deeds. There's people that also can do like the equivalent of a notarization. You always have to have something notarized before it can be filed in County Hall. They can't file things without having them notarized. And it's notarized to ensure that it's an authentic document. At the bottom of page 70, we talk about the grantor and the grantee. Just give that a read through on your own. Very rare does a state ask questions about what's the legal age to purchase property and what if you're married and the exceptions. They really don't care about that. There's too many other things to really focus on. I mean, think about it. Most kids today are living at home until they're in their 30s and 40s. I guess you're still a kid at that age. I don't think you have to worry about 15 and 16-year-olds or 17-year-olds running around trying to buy real estate so that you have to worry about that. But just give it a cursory read through. As we continue on page 71, just finish reading that first paragraph on your own, and then we see the habendum clause, and we know that when we hear the word habendum, we think to ourselves to have and to hold. And then we talked about the acknowledgement before, so just read that through again. And then we talk about delivery of the deed. So before a transfer of title by deed can result, the deed must be actually delivered to the grantor or his or her legal representative. And it has to be accepted by the grantee. So title is said to have passed when the deed is delivered. So then we talk about different types of deeds that are used. You want to know these. Full covenant and warranty deed. That's the best kind of deed we can get in New York State. It's actually the best kind you can get in the entire country. So full covenant and warranty deed. Usually when the word warranty is in there, that's how you know that we're talking about the best kind of deed that you can get to a property. And the Erie County Bar Association and most bar associations require that. It's in the pre-printed forms that real estate agents complete. And when you review your contracts with your broker that's going to sponsor you, you'll notice that as you read through. And we really encourage you to read all the different documents that you use in real estate once you're in the business. You know, once you worry about passing your exam and then you pass it, you know, you want to be able to just give a cursory review after you've read it all so that when your clients are sitting with you, that you're not reading line by line. Make sure that you can summarize it for them. It's much more professional if you can do that. The second type of deed is the bargain and sale deed with covenants against grantors' acts. And then the third one is without covenant against grantors' acts. And we'll talk more about that as well. Quitclaim deed, we say, is typically not the best kind of deed to get. Because with a quitclaim deed, you're only getting the rights that the person says they have. So I could give you a quitclaim deed to the Empire State Building, and it would be 100% legal and 100% have no value, because it literally gives you only the rights that that person thinks they have or say they have. And of course, executor's deeds and referee deeds, will get into specifics shortly. At the bottom of 71, we talk about the different warranties that are part of a full covenant warranty deed. Make sure to read that on your own. You want to go through it carefully. We have some video segments that will reinforce this too. Then we look at page 72. In the third paragraph, many real estate sales agreements that are created with the efforts of local real estate boards and bar associations require that a full covenant and warranty deed be delivered to the seller after all contract contingencies have been met. So in upstate New York, we use the warranty deed. In other parts of New York, the bargain and sale deed with covenant is more usual. So whatever's typically used, and you meet with your broker, you know, this course is not meant to prepare you, and the state curriculum doesn't allow us teach you how to fill out a contract. That's not part of the program. Your broker does that. That's all part of what your broker does when you associate with them. And they tell you what software to use and what phrases to use. But please remember, when you do fill out a contract, make sure there's some place in there that you're always putting subject to both buyers and sellers' attorneys' approval, so they can't turn around and say that you're practicing law. And make sure to run this by your broker too. Run that statement that I just shared with you now with your broker so that they're on board with whatever you're doing. And if they don't want you to do it, I would ask why. Why do you not want me to put that phrase in my contract that I'm preparing? I'd love to hear the reason. Unless it's already in there. It could be in there to one degree or another, and if they're using a form that has it, well, then you got it, so you don't have to worry about it. The second last paragraph on this page, bargain and sale deed with covenants against grantor's acts. We call this a special warranty deed in some cases. So with these types of deeds, the grantors imply that they have title to the property and add only one covenant. They state that they have done nothing to encumber the property while it was in their possession. We say that this type of deed is often used by fiduciaries, executors, corporate entities, and trustees. So I would underline that and be familiar with what kind of deed do you typically get to settle an estate. A bargain and sale deed with covenants against grantor's acts would be, because executor of an estate goes along with bargain and sale deed. Okay, so make sure you know that for test purposes. In the last paragraph of this page, a bargain and sale deed without covenant contains no warranties or assurances. Please know that. Bargain and sale deed without covenant contains no warranties or assurances. It does, however, imply that the grantor holds title to the property. So the grantee has very little recourse if defects later appear in the title. The bargain and sale deed without covenant is used in foreclosure and tax sales. Please know that. Highlight that and put little stars next to it. Bargain and sale deed without covenant is used in foreclosure and tax sales and as a referee's deed. So bargain and sale deed is also known as a referee's deed. And those types of deeds are typically used for foreclosures and for tax sales. Tax sales are when municipalities sell properties that they foreclosed on because the taxes weren't paid on the property. Make sure to put those on your index cards for your flashcard review. We continue on page 75, and 75 is where we're going to wrap up this session before we look at some more video clips to help reinforce everything that we've covered. And there's a lot in this chapter. There's actually a lot in session C that you probably are a little mentally tired at this point. I'm sorry about that. It's always been that way, and it's always going to be that way. So at the top of page 75, a quitclaim deed provides the grantee with the least protection. Please know that for test purposes. It contains no covenants or warranties, and it only conveys whatever interest the grantor may have. So if they have no interest in the property, it will grant you nothing. In the next paragraph, quitclaim deeds are commonly used for uncomplicated transfers within a family, and it's also used quite a bit for divorce settlements. In the next paragraph, an executor's deed is a bargain and sale deed with covenant. A referee's deed contains no covenants or warranties, although it does imply ownership. In the middle of 75, we talk about the fact that you come into contact with all types of real estate instruments as a real estate professional. We talk about a contract. The two main types of contracts that you're going to see as a licensee are listing agreements or listing contracts, as well as purchase contracts. A contract is a voluntary agreement between legally competent parties to perform or abstain from performing some legal act. It's supported by consideration. Contracts may be expressed or implied. They could be unilateral or bilateral, executory or executed, valid, unenforceable, voidable, or void. In the box, you want to know the difference between an express agreement and an implied agreement. So when we say express, we mean intention in words, whereas implied is your demonstration through acts and conduct. Please know that for test purposes and for the state exam, of course. So in an express contract, the parties state the terms and they show their intention in words. An express contract may be either verbal or in writing. A listing agreement is considered an express contract between seller and broker. And we conclude at the bottom of 75 with fiduciary. So you might remember fiduciary from when we covered law of agency. When a person is hired to act on behalf of another, an agency relationship is created. The person hired to work for another is known as a fiduciary. So in real estate, the licensee is the fiduciary. Anyone who holds that license, either real estate license, broker's license, you are the fiduciary. The person that's doing the hiring is the principal or the client. In a fiduciary relationship, we always put the client's or the principal's needs above and beyond everyone else's, including your own, including the agent's own. So let's take a look at some video clips to help reinforce what we've just covered.
So, first let's start with the form of ownership. So a condo is basically like purchasing a house. You're purchasing real property. You own it. A co-op is a little bit different. It's a corporation, and you're purchasing shares of stock in that corporation, and then you're signing a lease giving you permission to live in that space. And one of the things that people don't talk about enough is the differences in financing. Now, when you're purchasing a condo, you're taking out a mortgage just like you would if you're purchasing a house. A co-op, you're actually not. A lot of people don't realize that. But in a co-op, you're just taking out a loan to purchase the shares. And this does make a difference in things like closing costs. Condos typically have much higher closing costs. And one of the reasons is because there's a mortgage involved. You're paying mortgage tax and title insurance. You know, co-ops always have, less in the way of closing costs. The down payment as well can be different. In the past, we used to always say condos, you can put down 10%, co-ops 20% or more. However, nowadays, when you get financing, people aren't really putting any less than 20% down. However, co-ops, it can go up from there. It can be 25%, 30%, 50%. So just keep that in mind as far as the down payment. Condos are also more expensive than co-ops, and there are less of them. So when you're looking for an apartment in Manhattan and you have a specific neighborhood and a specific price range, be prepared that most of your options are probably going to be co-ops. At least 80% of them are going to be co-ops. There's fewer condos, and condos come at a premium because of their freedom of ownership, which we're going to discuss. Now, there are some key differences between a co-op and a condo when it comes to the approval process and rules once you are to move into the building. And one of the big ones is subletting. So in a condo, you can pretty much sublet as much as you want. You never have to even move into the building. And condos are investor friendly. So if you're an investor, a condo is definitely the way to go. Co-op typically has very strong restrictions as far as subletting goes because they want the owners to occupy the apartments. And a lot of people don't understand why, but a co-op is more of a community of owners. And they want the owners to live in the apartments, take care of the apartments, take care of the building, care about the building, and not have a bunch of transient renters, coming and going. Another big one is the board approval process. Now, when you're purchasing in a condo, if you can afford to purchase the apartment, if you can get a mortgage or if you're paying cash, that's pretty much it. However, in a co-op, there's a board approval process. You have to be approved by the board because they really want to make sure that if you're moving in, you can afford to, pay for the apartment and you can afford to live there. Post-closing liquidity. Now, one of the things the co-op will look for is they want you to have a certain amount of money in the bank liquid after you close. Now, the rule of thumb here is 2 years of maintenance and mortgage payments in the bank after closing. So this means after you put your down payment down and pay all the closing costs, another 2 years of maintenance and mortgage payments in the bank liquid. Now, not all co-ops are the same. This is just a rule of thumb. Some of them don't even have a restriction like this, and others are very tight about it. Debt to income ratio. Another thing they will look at is how much debt you have versus how much income you earn. And this includes the payment that you're going to have once you move in, the monthly payment. Keep in mind on this that the banks have a different number than the co-ops. Co-ops are a lot stronger on their debt-to-income ratio requirement, which you can contact me and I'll tell you how to figure this out, or just Google it online. They also will probably have some restrictions on parents purchasing for children or with children, or even parents gifting you a down payment. If you're a first-time buyer or somebody where your parent is gifting you the down payment, you're going to have to check and make sure that's okay with the co-op. Typically it is, but you're going to have a letter from the parent stating that this is a gift and they don't expect any payment back from you, just so it's not counted as debt. And of course, there's the board interview. So after your co-op board application gets approved, you're typically going to have to meet with members of the board and they're going to interview you. And they are going to put you on the spot. It's going to be a bunch of people and you sitting there being interviewed. And it can be very different from board to board. Sometimes they will sit there talking to you about your financials. They might even have your application in front of you and grill you on the financials. There's other times where they won't even talk about the financials, and they'll sit there and talk about their house rules, making sure you understand, the rules of their co-op. So it can be very different from board to board, but just be prepared to be put on the spot and to have an interview where there's a bunch of people sitting there interviewing you. So those are the basic differences between co-ops and condos. Now keep in mind, if you are considering purchasing a co-op, which I'm sure a lot of you are, that they are a lot different from co-op to co-op. They don't all have the same rules. I gave you the basic guidelines, but there are certain co-ops that don't even look at post-closing liquidity or debt-to-income ratio. There's some that are just completely case by case. There's others that allow unlimited subletting. And luckily, if you're working for a broker, after they understand your needs and what you're looking for, they can call every single other broker who's representing the seller and make sure that they understand what the requirements are and what they allow and what they don't allow, and hopefully they'll vet out a whole bunch of them beforehand. But just keep in mind that they aren't all the same. So I hope that gave you a little bit of insight on co-ops versus condos.
New York City's a little different in that we live in apartments by and large. We're also a rental city for the most part. However, when you're going to purchase, you're going to find two kinds of animals. One's called a condominium, one's called a cooperative. We're a city of co-ops. The reason we're a city of co-ops is we wanted to exercise some control here in Manhattan of who our neighbors are, in a positive way. We live vertically. We have people who are above us, below us, beside us. The cooperative process is a way to ensure that you know who your neighbor is going to be and that you're going to be living in these tight quarters. It makes sense. But to someone who's not from our area, it's kind of a scary thing. So let's start with the concept that everyone understands what a condominium is. You buy it, you get a mortgage, it's just like a house. We all pretty much know how that works. Cooperatives are a little different. For all intents and purposes, you're buying your apartment. It's just structured legally in a different way. You are actually buying shares in a corporation. The primary difference between a cooperative and a condominium is that this form of ownership. And there are some hurdles you have to overcome in purchasing a cooperative. Each co-op, each building sets its own financing requirements. So this is a big thing for people not from New York to grasp. You may be able to get 100% financing from a bank, but the building, the cooperative, won't allow you to finance 100%. In Manhattan, this is a bit of a struggle for a lot of people because our average is probably a 25% down payment. Many buildings require that you put a 50% down payment. Co-ops also require that you pass a board interview. So once you have found an apartment, once you fall in love with it, once you negotiate it, once you sign a contract, you still have to do something and get a mortgage or a loan, a co-op loan. You still have to pass a board interview. You lay your soul bare, tax returns, letters of recommendation, all of the financial backup for your assets and net worth, anything you could think of, you have to create a package and send it to these strangers. That's a little frightening and a little daunting. These people you've never met before review it. Then they ask you to come for an interview. I say it's like joining a country club. You come, you meet these people, you sit down, they ask you questions. Usually it's a pleasant social meeting, but it is a business meeting. And then you wait a few days to decide whether or not they like you enough to live in their building. It's something for people who aren't from here to get used to. Once you do it, once you close, it's just like anywhere else. And if anything, the fact that co-ops are a little stricter about who comes in, because as I said, we want to know who our neighbors are. We're living in a communal space. It's sometimes a better environment. Many co-ops don't allow people to rent their apartments, or if they do, they allow them to rent them for a very finite period of time, 1 to 2 years. And that means that everyone who lives in your building is an owner who cares about the building at the same level you do. Let me talk about the pricing differences between co-ops and condos for a minute. I like to ask the question, who buys a co-op? Co-ops are for people who are going to live in that apartment. They're going to be here. They're not going to be living in multiple locations for the most part. This is going to be their home. That's very important to us. Condominiums can be bought by anyone. A person with foreign money, someone who wants to invest and rent it out, someone who wants to use it as what we call a pied-à-terre here in Manhattan, where they're just using it, a couple days a month or something. So the condo has much more flexibility, also because it's easier to purchase. You can put down less money. While you still have to fill out a pretty complete application and lay your soul bare there too, you don't run the risk typically of being turned down to purchase it. It's a much simpler process. Because of that, cooperatives are going to be less expensive, apples to apples, than a condominium. So while you think, hey, this is great, I can easily buy a condo in New York, there's a little penalty. Because it's easier, there's a premium placed on it. If I put 2 apartments next to one another, which were identical, one was in a cooperative and one was in a condominium, there probably would be a 20 to 30% price increase or price difference higher in the condominium than in the cooperative, for all the reasons I mentioned. Easier purchase, greater flexibility with use, etc. So it's really great. You think, oh, I'm going to buy a condominium, but beware, you're going to pay more. I would prepare someone in New York who is thinking of purchasing a condominium or a cooperative in the same way. The first thing I like to say is, I want to get your financial passport in order. That's the same for anywhere in America. It's really important for someone to drill down. Believe it or not, some people don't even know how much they make in a year. They don't know what their benefits are. They don't know what their taxes are. So I try to educate people and tell them, first of all, know precisely what your income is. Talk to HR in your company. Talk to a mortgage broker immediately.
First choices you're going to have to make when you decide to buy a home is what type of home you want to purchase. Do you want to buy a condo or co-op, a townhome, a detached home? As I explained in my home buying process video, this is going to be one of the first choices you're going to have to make as a buyer. I personally can't make the decision for you, but I can help with explaining the differences so you can make a choice that works best for you. Let's start off with what's commonly the 2 most unfamiliar of the group: condos and townhomes. A condo is basically an apartment that you own. You mainly own the airspace in between the walls. And because you don't technically own the roof or exterior or the building, you pay a higher HOA fee. In parts of my market, HOA fees can run $300 to $400 on a $150,000 condo. But there is a benefit to high HOA fees. Presuming the management is doing a good job with the funds, you won't have to ever pay for a roof. Garbage and water is usually included in the HOA fee, and so forth. Maybe there's even a pool and some nice landscaping. All this is included with your HOA fee. Another note, with some HOAs, they fix a majority of problems that you and other owners could not have caused. For example, if the condo above you starts to leak into your unit and it's at no fault of the owner upstairs, then the HOA will likely cover the costs. If, for example, the owner upstairs flooded the bathtub or a toilet or never did really any regular maintenance, then that would be a separate homeowner's issue. Townhomes are kind of in the middle of a regular home and a condo, and it depends on how it's really set up. For example, if your townhome complex shares roofs with the neighbors, usually the HOA is set up to repair and replace it. However, if your deck starts to need major repair, you're likely going to be responsible for replacing it, whereas a condo will replace it and fix it for you. Townhomes commonly are more expensive than condos as well, but the HOA fees are usually less, mainly because there's less common responsibility. Detached homes are simply homes that have no neighbors sharing walls, and almost always the most expensive of the three property types. With the home, you're responsible for all the repairs and maintenance. If the roof goes bad and needs repair, you have to pay for it. If there's a leak or the deck need repair, you have to pay for it. Landscaping must also be done by the owner. All the garbage and water bills are also paid directly by you and not an HOA. However, in some developments, mostly newer ones, there's a small HOA fee. Usually this is paid by the neighborhood to maintain a local park and the greenery near the roadway, but usually not your own front lawn. Of course, there's also other versions of the primary three property types of housing. Co-ops are basically condos which you buy a percentage of. You commonly will see co-ops in areas like downtown San Francisco and especially in New York. Then there's homes which share a wall with a neighbor, usually called duets. There's also others that are less common nationally, but they may be more common in certain local markets. When it comes down to it, it's all a matter of personal preference. If you don't like to have to save up for any large repairs and you like the idea of close community or apartment style living and don't mind the privacy of your own yard, a condo may be the way to go. If you prefer to take care of everything yourself and like the idea of fully controlling all your bills, repairs, and having your own place to do with as you wish, then a detached home is probably going to be your best bet. And if you're somewhere in between where you would like to have a small yard but don't mind sharing expenses, then maybe
today's video is all about helping you avoid mistakes when purchasing a condo. Purchasing a condo is great for a lot of reasons. However, there are a few things that you want to be aware of when you are purchasing in a condominium community. So in today's video, we're going to be touching on 5 mistakes to avoid when you're purchasing your condo. So let's get right into it. I love starting a video and then immediately getting to the meat, the heart of the content. Let's start with number 5, which is parking spot. Not knowing the size and location of your parking spot when you're purchasing a condo. Guys, you should not find out the location and size of your spot on the final walkthrough inspection. You know that thing you do right before you close? Don't do that. Stop doing that. Parking spots are extremely valuable. Mistake number 2 is not knowing about the potential for having a storage unit here with a storage unit. So be sure you're double checking with your agent because sometimes on the listing it might not be included. So check the listing, check the tax record, ask the agent, because meanwhile, you know, you're trying to haggle out the last like $150 on the home inspection, when in reality, the seller and the listing includes a storage unit. Some buildings value these at $5,000. Be sure you double check and triple check, because a lot of times it's not readily available. It's not readily apparent if you do have a storage unit or if you don't. So be sure you're checking up on your storage unit. Number 3 is restrictions. So if you've never lived in a condo before, there are some rules and regulations that you need to abide by. The most talked about ones are usually the pet restrictions, grilling restrictions, and move-in restrictions, all 3 of which you need to pay attention to. So you're going to be getting the condo docs. And guys, the condo docs are like, they could be like 400, 500 pages. No one wants to read them. But if you just don't read them, I mean, you might be surprised, or you might be taken aback if you're thinking about getting a pet or thinking about putting, you know, that gas grill on your balcony, you know, 1 foot from the interior. So, you know, there are rules, right? You need to read the rules. So none of them are going to be too harsh, but be sure you actually make an attempt to understand the basic rules and regulations. Mistake number 4 is not knowing the percent of owner-occupied units. Now, I don't expect your real estate agent or the listing agent to know this off the bat, off the top of their head. They could, but your best resource for this would be to contact the condo management office directly. Now, this information might also be found on the condo questionnaire, but at that point, you're already under contract. So why is this information important? Why is this investor to owner ratio, or call it renter to owner ratio, important? Well, because if the renters become significantly higher than the owners in terms of ratio, lending becomes more difficult. And when lending becomes more difficult, buyers have a harder time purchasing in that community. And when it's tough for buyers to purchase in the community, it's tough for sellers to sell their property in that community. And when that becomes more difficult, prices will go down because sellers have a more difficult time finding the right buyer. In some communities, there are rental caps on the community, which means only so many people can rent out their unit, but it's not that common. However, you should look to see if it's common, because if your grand master real estate investing plan is to purchase your condo, live there for 3 years, move out, and then rent it for the next 7, but there's a rental cap, some rental restrictions, that might punch a huge hole into your whole real estate investing plan. So be sure you're looking at owner-occupied units to investor-occupied units, and to see if there's any rental cap or any rental restrictions in your community. Mistake number 5 is not thinking about the resale value, and I want to talk about this in 2 different facets. The first one is improvements, modifications that you make. Now, guys, you're allowed to improve your condo, go for it, but if you make like extravagant finishes and have bold fixtures, that might look great for you and for your lifestyle, go for it, but for a lot of people it's going to look like trash. So when you go to sell it, the value's not going to be there. If you make these improvements, just know 2 things. One, the value, the money that you put in, you're not getting it back. You can kiss it goodbye. You're not going to get that dollar for dollar. Nowhere near. And 2 is that your real estate agent's probably going to recommend you do something neutral, because the goal is to appeal to as many people as possible. And when you have some bold, painting, some bold walls, some extravagant finishes, that really defeats the purpose of trying to appeal to everyone. Hopefully your agent doesn't say, hey, this $50,000 kitchen, yeah, tear it all out and get something bold, get something bland. But their goal is to appeal to everyone. So you might have to take out some fixtures. You might have to tone it down a little bit. So when you're making these modifications, just know that those modifications are for you. When you're looking to sell, let's tone it back just a little bit. And part 2 of this equation of not thinking about the resale value is not putting an emphasis on those features and benefits that will help you sell the condo for more in the future. Let me give you one very specific example. When you're looking at condos, a lot of times you're going to have the same floor plan, but one unit will have an outdoor space, a balcony, or a patio, while the other will have a sunroom, enclosed, livable space. And my buyer will say, Matt, I don't care, I just don't have a preference either way. Fine, that's all good and dandy. I'm indifferent on so many things. When I look at the tax records and when I look at the comparable properties, when I look at the recent solds, I notice that, hey, sunrooms sell for $10,000 more, depending on the community. So you might not care either way, but I guarantee when you look to resell, you're gonna care about the sales price, and you're gonna care about which unit will get you a higher price. So even if you don't care now, think about what a feature and what a benefit is that someone might care about in the future. Whether that's a balcony, a fireplace. Fireplaces don't really add too much, but some people love fireplaces and want a fireplace. I don't get it either. A fireplace in a condo, it's kind of a waste of space to me, but that's, again, this is my opinion. And then if I look in the sales records and see that fireplaces sell for a higher price without being priced higher to begin with, if that makes sense, I personally might go after the ones that have a fireplace, because that's like untapped potential. So part 2 of not seeing the value is think about the resale value and think about a feature or a benefit that would help you resell it for a higher price. There you have it, the 5 mistakes that condo buyers are making, but you're not making it because you watched this video. Now you're going to avoid those 5 mistakes.
In most of the country, condominiums, also known as condos, are much more common than cooperatives, also known as co-ops. Here in New York City, the opposite is true. Co-ops far outnumber condos. However, today, most new construction in New York City is made of condos. When you buy a co-op apartment, you're not buying real estate. Instead, you're buying shares of the corporation that owns the building in which you wish to live. When you buy a co-op, you'll receive a stock certificate and a proprietary lease. When you buy a condo, you'll be buying a portion of the building in which the condo unit is located. You actually own the space within your unit. You receive a deed to show your ownership. The owner of either a co-op or a condo pays a monthly fee. In the case of a co-op, the fee is called a maintenance fee. In the case of a condo, the fee is called a common charge. The monthly fee paid to the co-op for an apartment is usually larger than the monthly fee paid to the condo association for a condo unit of comparable size. The vast majority of co-ops carry a mortgage. The maintenance fee includes that co-op owner's share of the mortgage and taxes on the building. The co-op owner may deduct a percentage of the maintenance fee against the owner's taxes. In addition to the mortgage and taxes, the maintenance fee includes expenses for maintenance and upkeep of the building. Although condos don't carry a mortgage, the common charge for a condo includes maintenance and upkeep of the building. Although a co-op is usually less expensive to buy than a condo, buying a co-op is riskier because you are buying shares in a corporation. If the corporation is in bad financial shape, you can lose your co-op and the money you invested in it. Even worse, after losing your co-op, you can still have to pay the co-op loan. Many lenders will not lend money for a co-op purchase if the co-op consists of only a few units or if too few of the units have been sold. Beware of co-ops that have large balloon payments coming due or tax abatements that will be ending. In addition, be aware of co-ops that do not own the land on which the building is located. They may only have a lease on the land for a set period of time, at the end of which the land will revert from the co-op to the owner of the land. In most cases, the purchase of a co-op requires approval by the co-op board. In addition, the right to rent a co-op apartment to others may be severely restricted. Both co-ops and condos have boards of unit owners. In addition, both co-ops and condos have rules that the apartment or unit owners must follow. In both co-ops and condos, a special charge known as an assessment can be charged to the apartment or unit owners in the event that expenses for the building become needed. When buying a co-op or a condo, make sure that they have a healthy reserve for future repairs. Also, when buying a co-op or a condo, find out if there is a tax abatement of some type, and if so, when it will expire and how much its expiration will raise your taxes. Also, in both co-ops and condos, the monthly fee may have to be increased to meet increased costs for operating the building.
My name is Joseph Janis, and this is a quick overview of the New York foreclosure process. The foreclosure process in New York is actually a legal process, meaning the foreclosing lender must file a lawsuit against the homeowner before they can actually take possession of a property. So the process begins when a homeowner misses a mortgage payment. Once you are 30 days late with a payment, and before the lender can file a lawsuit to foreclose, they will send an acceleration letter indicating that the homeowner is in danger of losing their home, and they may file a lawsuit within 90 days. 90 days later, the lender will file what's called a lis pendens, which is a public filing with the county clerk. This filing indicates to everybody on record that the title to a property is actually being contested. This is the official start of the foreclosure process. The homeowner then has 20 days to respond. So, next question is, should the homeowner respond? Well, if the homeowner doesn't respond, then the homeowner is in default, and the lender files a motion with the court for an order of reference, or to have an auction referee assigned to the property. If the homeowner does respond, then the court requires a discovery process, which requires the lender to file a motion for a summary judgment before they can get the order of reference. This motion is an additional step that the bank must go through. It may add 2, 3, 4, maybe even 5 months to the foreclosure process. So just by responding to the notice, a homeowner can buy themselves more time, and time is what you need in any foreclosure situation. Now, once the order of reference is obtained, the court assigns a referee, who is usually an attorney, who will calculate the total amount owed on the loan. The referee files the numbers with the court, and the lender files a motion for a judgment of foreclosure and sale. This is a legal order authorizing the referee to sell the property. The court approves the motion. The referee will then schedule the auction date, and they will advertise the foreclosure auction in 1 or more newspapers with typically 4 to 5 weeks of notice. After the 4 to 5 weeks, the house is actually auctioned at the steps of the courthouse. This is the New York foreclosure.
In an easement, someone is allowed to use someone else's land for a certain purpose, such as Ellie here, whose easement allowed her to walk through Ollie's property. In an easement by necessity, First, we need severance of unity or severance of title, which we'll explain in a moment, and also a necessity for the easement at the time of the severance, which we'll also explain. Severance of title basically means at one point the property was owned by only one person, but now the property's been divided among more than one person. And here necessity of the easement means one person really needs the easement. It's absolutely necessary. So here's a piece of land surrounded on three sides by trees, and it's adjacent to a public road. And this land is owned by Ali. He has a house on the east next to the road, and a cabin in the back on the west side of the property. But one day Ali decides to sell the cabin on the west and the land that it's on to Ellie. So now Ellie has title to the land on the west, and Ali still has his title to the land on the east. Well, the next day Ellie decides to go to work, so she cuts through Ollie's property to get to the public street. Ollie gets upset about this, though, and he tells Ellie not to trespass on his property. Ellie protests that she didn't have a choice, and she didn't. The trees completely cut off any other route. It was absolutely necessary for her to cut through Ollie's property if she was going to get to the road. And then it occurs to Ellie, perhaps I have an easement by necessity. Well, remember, the first thing that we need is severance of unity, or severance of title. Now, at the beginning of our story, only Ollie owned the land. Only Ollie had title to the property. But then title to the property was severed. Ellie acquired a portion of the property. That sale was severance of unity, severance of title. That satisfies our first requirement. Our second requirement is a necessity for the easement. So let's look at the time of the sale when Ellie acquired the western portion of this property. At that point, it was absolutely necessary for Ellie to pass through Ollie's property if she wanted to reach the road. When Ellie walks through Ollie's property, she's doing it because she has to. Crossing the property was absolutely necessary if she was going to reach a public road. So now we have severance of title, and the easement was necessary at the time of the severance. Ellie should have an easement by necessity to cross through Ollie's property.
What's an appurtenance? Well, this term appurtenance means anything that's attached to the land and transferred along with it. So when you buy and sell real estate, the land is the basic real estate, and anything tangible or intangible that is transferred along with it is referred to as an appurtenance. So we have a little diagram here, and let me ask you a couple of questions. That house there, that building, real or personal property? Real property, so it's an appurtenance. If the land is sold, the house is sold. How about the trees behind it? Real property, so that's an appurtenance. How about those cows? Well, they're personal property, so they would not be an appurtenance. How about that pink or purple mine in the background? That's right, it's real estate. Those mineral rights are real property, intangible, but they are real property, therefore an appurtenance. I don't know if you can see it, but way in the background there's a field of corn surrounded by a fence. That field of corn, real or personal property? It's personal property, it's not real property, so it's not an appurtenance. But the fence around it would be an appurtenance. And how about the water? Well, water and water rights are real property, so that would be an appurtenance as well. So let's talk about the tangible appurtenances. For example, buildings, trees, fences, sidewalks, any sewers, any improvement that man makes to property is considered to be an appurtenance to the land. Perennial plants, the landscaping that you install, that's real property as well, so would be an appurtenance. Perennial plants, plants that renew themselves year after year, are referred to as fructus naturalis, meaning fruits of nature. The term emblements, which we'll define in a second, emblements are personal property. So what's an emblement? Well, an emblement has two definitions. The first one is a crop itself, like that field of corn or a field of cotton. The second one is the right of a tenant farmer to go on the land after the lease has expired to harvest his or her crop. So the crop itself is called fructus industrialis, meaning fruits of industry. So crops are personal property, not real property. And the term that we use to define them is emblements. And again, the right of a tenant farmer to go back on the land after expiration of the lease in order to harvest the crop because the crop took longer than expected, for example, to mature. That right of that farmer is referred to as an emblement. So what are the intangible appurtenances? Well, for example, all the rights that go along with property, mineral rights, air rights, water rights, many of the rights and some more that we'll define in just a couple of minutes. How about easements? An easement can be both an appurtenance and encumbrance. It depends upon your perspective. For example, if I have an easement across your property to enter and leave my property, that is a benefit to my property, and if I sell my property to a third party, that easement transfers along with it. So that easement is an appurtenance that I have to my property. Whereas if your property is the property across which the easement lies, that is a burden on your property. It's an encumbrance on your property. So to you, that easement is an encumbrance. It's not an appurtenance, but to me, it's a benefit. Therefore, it is an appurtenance which transfers with the property if and when I sell it. So there's a term that I want you to understand called the bundle of rights. And this term actually comes out of the Old English, where back in medieval times when a property might have been sold, all the villagers would come out to witness this transfer of ownership. And the seller might pick up a handful of earth and pass it on to the buyer, signifying he or she was transferring the land. And then the seller would take a bundle of sticks and pass those sticks along to the buyer. And those sticks represented all the rights that went along with ownership: the right to sell the property, the right to possess it, the right to lease it, the right to plant crops, the right to hunt and fish on the property, and so on. So this concept of the bundle of rights arose out of this Old English ceremony actually was called the livery of season, the transfer of ownership, in other words. And today we still use this concept of the bundle of rights when we talk about different aspects of ownership. Here's, this schematic is a little bit hard for you to see, but it's a cross-section of a piece of earth. And you can see there's water flowing through it, so some of the rights would be water rights. Above that would be air rights. There's agricultural rights. Below the ground, there's mineral rights. Over on the right-hand side, there's development rights where those buildings are, and many, many, many other rights. Two of the terms I'd like you to be aware of, the first one being riparian rights. The term riparian refers to water. And riparian rights are the rights that an owner might have next to a river or stream. So if you own property next to a river or a stream, in some states, not all states, you may have the ability to use that water. Another term is littoral rights, and littoral rights refer to the zone between high water and low water where a property owner has property along a lake or the ocean. So in most instances, of course, the owner does not have rights to build or develop in that littoral zone, even though sometimes people do it, sometimes mistakenly, but it can pose some problems. So these two terms are terms you might hear: the term riparian rights dealing with water rights, and littoral rights, rights that someone might or might not have along a tidal zone. Now this term appurtenances and the bundle of rights. Let's take just a quick look and name a number of these appurtenances. The trees and all the other plants, they're appurtenances. The house and other buildings are appurtenances. The fences and any other improvements. The water or water rights. The coal or mineral rights. The air rights. The right to lease the property. The right to sell the property, of course. And the last one I'll mention here is the right to will the property. Your right to pass your property along to your heirs is a very important right. In fact, how many of us would be willing to buy a property if we did not have the ability to will it? So all of these taken together, plus many more that I haven't listed here, are referred to as the bundle of rights, and they are all appurtenances to real property. What does that mean? It's something that's attached to the land, tangible or intangible, that would be transferred along with it. So that's our little discussion on appurtenances.
Let's talk for a minute how property is legally described. So when I think of my house, and most people connect that with the address, right? I live at such and such address. But when we're looking at insuring a parcel, we insure legal descriptions, right? And those could be plats, meets and bounds. Walk us through the kind of the nuances between both.
Well, the lot and block is the simplest one, right? If you live in a subdivision that has lots, right, it's a plat. For example, I'm in lot 54 of Chalet Estates. Pretty simple.
Yeah.
But when you start getting into the more rural areas, that's where you get into what we call meets and bounds descriptions. Yeah. These are the descriptions that start at a particular point and go a certain distance. They go 89 degrees, so many minutes, so many seconds west, and then so many then we go north, and we're basically trying to map out what that looks like. I always describe it as when they're looking at a title, it's like those posters that if you stare long enough at them, you can see the whale. I've never been able to see the whale, but our folks, our title examiners, they can see from the description basically the shape of the property, what it's all going to look like. Yeah. And those legal descriptions, the meets and bounds, those are the most challenging because we got to make sure that everything is correct, that the old deed matches the new deed, that matches the survey, and matches the tax legal description. So all those things have to match. Pretty easy in a lot and block. A little more challenging in the meets and bounds.
And the fact that it's what we call ties out, right? That when we're walking through this, we end up at the point of beginning once we're done with the legal description.
Exactly, because every once in a while you might have a couple degrees off, and that can go a long ways to misdescribing the property if it's an 800-foot length.
Yep. Emphasizes the value of surveys, for sure. You'd be surprised how many small issues over the years have taken place that are identified in a current survey.
That's right.
Review of legal descriptions, we will demonstrate how a surveyor will move around a lot, identify the 3 types of legal descriptions, demonstrate how to convert square footage to acres, and define the words check, township, section, benchmark, datum, and spot survey. We will also introduce basic area math calculations by working questions for you. Just relax, listen, and learn. To create a simple legal description, imagine you are a surveyor standing in front of this property. Your job is to describe the boundary lines. Where are you going to start? Surveyors call the starting point a point of beginning, or POB. Next, how are you going to move around the lot? Do you want to move around the lot in a clockwise or counterclockwise direction? There is no rule regarding the direction a surveyor must take when moving around the lot. However, once the movement is decided, it must be used consistently in the subdivision. Let's move around this lot in a clockwise direction. Standing at the point of beginning, moving around the lot in a clockwise direction, are you facing north, south, east, or west? To keep this simple, let's say you're facing north. The next step would be to measure the distance from the point of beginning to the next monument. A monument is a natural or artificial marker that identifies the intersection of imaginary boundary lines. Examples of monuments are benchmarks, iron spikes, wooden stakes, and fences. The measurement from the point of beginning to Monument 1 is 100 feet. So that legal description would read, starting at the point of beginning and moving due north for 100 feet. Monument 2 is due east for 150 feet. The next description is a bit more complicated, so please listen carefully. To measure angles, a surveyor will use a compass which is divided into 4 equal quadrants, and then the specific degrees are measured. In our diagram, draw an imaginary straight line from the monument to the bottom boundary line. When this angle is measured, the description would read south 30 degrees east. The distance is 115.5 feet. The final measurement would close the legal description, meaning it would return it to the point of beginning. This description would read, traveling due west for 207.7 feet to the point of beginning. Please note, this is a very simple example showing how a surveyor would move around the lot. A legal description is a formal description of real property, which could be given to a competent surveyor, and she or he could locate and identify the property using that legal description. The legal description should uniquely describe the subject property and determine the exact boundaries, that is, the location and dimensions of the property. The three types of legal description are meets and bounds, lot and block, and rectangular survey. Let's review each of them.
Land in the original 13 colonies, plus Maine, Vermont, Tennessee, Kentucky, Texas, West Virginia, and parts of Ohio were surveyed with the meets and bounds surveying system. The other states used the rectangular survey, which we will review in a few minutes.
Today, we have sophisticated survey equipment to determine measurements and angles, and the angles can be measured in degrees, minutes, and seconds. In the pioneer days, a legal description could read, starting at the forks of the road and meandering north along the creek bed for 13 chains to the tall oak tree. Follow the fence line east for 20 chains to the big boulder, then south for 13 chains to the walnut tree, then west along the road for approximately 20 chains to the point of beginning, and it contains 26 acres, more or less. For your information, a chain is 66 feet.
Meets means to measure distance, while bounds indicate direction. A meets and bounds is also known as a boundary survey. The meets and bounds survey is characterized by degrees, or if the surveyor is really specific, the description can include degrees, minutes, and seconds. A legal description reading south 45 degrees east for 150 feet would be a meets and bounds survey.
In 1785, the federal government began using the rectangular survey system to identify government land. Their goal was to create a system that would measure the land in a uniform fashion. The rectangular, or government survey, is based on two sets of intersecting lines known as principal meridian lines, which run north and south, and base lines, which run east and west. Principal meridian and base lines are based on longitude and latitude. Longitude and latitude are coordination points which describe any location on the Earth. If a captain of the ship or a pilot want to specify their position, these are the coordinates they would use.
The rectangular survey system was put in place with the Land Ordinance of 1785 so that we had a systematic means of organizing or surveying all of the blue states, which are the public domain land. Prior to the Land Ordinance of 1785 and the rectangular survey system, the state land states, which would be the 13 colonies, organized their land or surveyed their land with the meets and bounds system. Now, the meets and bounds system was a very organic system. It's just as you might imagine if you were just going to lay out an area of land based on the topography or the geography, the visible landmarks that you can see. In our sample here, we have a piece of land bordered by a creek or a river. We have demarcation of a felled maple, a marked oak, a big rock, the neighbor's land, a marker that was actually put there to designate a corner. You can see how it was very haphazard, well, systematic that person or that land, but very haphazard over a large period of land. Now, can you imagine what would happen if the topography or the land changed? The river moved, the maple was removed, somebody moved the designated marker, the whole survey system would fall apart and the person's property would not be as well defined. Great disputes could happen, and they did. Further, this would be terribly ineffective over a large period of land. Imagine all of the land in those blue states, the public domain land. So with the public domain system, we were trying to put together, or I should say Thomas Jefferson put together the rectangular survey system, and he was hoping to get a standard, consistent means of measurement for large areas of land, all of those blue states you saw on the map, and fixed points of reference that wouldn't shift with the topography, that he didn't have to worry if the river moved or the oak fell or the marker was moved. The survey would stay intact. Further, within each one of those boxes, those colored boxes like Sherman Township, the area is subdivided into 36 sections. So you can see how the sections are numbered. 1, 2, 3, 4, 5, 6, and it loops back and counts the other direction. It's not left to right, straight across like one would normally read. They're a backward S in terms of the numbering system. 1, 2, 3, 4, 5, 6, and each section is 1 square mile. So within each township, you have 36 square miles.
A habendum clause is a clause in a deed or lease that defines the type of interest and rights to be enjoyed by the grantee or lessee. In a deed, a habendum clause usually begins with the words to have and to hold. This phrase is the translation of the Latin habendum et tenendum that historically commenced these clauses in deeds. Technically speaking, the to have, Latin, habendum, is separate from the to hold, Latin, tenendum, such that the tenendum clause is sometimes considered a separate concept. Historically, the habendum clause dealt with the quantity of interest or estate which the grantee was to have in the property granted, while the tenendum clause addressed the tenure upon or under which it was to be held. Put differently, the habendum deals with the relationship between the possessor and the land, how the land is to be had, while the tenendum deals with the relationship between the possessor and his immediately superior lord, how the land is to be held. The obsolescence of provisions of the habendum clause must agree with those stated in the granting clause. For example, if the grantor conveys a time-share interest or an interest less than fee simple absolute, the habendum clause would specify the owner's rights as well as how those rights are limited, a specific time frame, or certain prohibited activities. For instance, many states, such as Pennsylvania, require a deed to have a habendum clause in order for the deed to be officially recorded and recognized by the recorder of deeds. Habendum clauses are also found in leases, particularly oil and gas leases. The habendum clause can define how long the interest granted will extend. Most oil and gas leases provide for a primary and secondary term. During the primary term, the lessee can hold the lease without producing. The secondary term is usually so long thereafter as oil and gas is produced in paying quantities. Bargain and sale deed is in United States real property law, a deed conveying real property without covenants. This is a deed for which the grantor implies to have or have had an interest in the property, but offers no warranties of title to the grantee. This type of deed is typically used in many states to transfer title. Under common law, this type of deed technically created a use law in the buyer who then gets title. Under the statute of uses, modern real property law disregards this subtle distinction. A bargain and sale deed is especially used by local governments, fiduciaries such as executors, and in foreclosure sales by sheriffs and referees. The fact that it comes without any warranties from the government means that the new owner may not have good title. If in fact, the city did not have good title or the city could not convey good title, then the new landowner is unlikely to be successful in obtaining a refund of the purchase price. Some states require a specific form to be used. Some states also allow a grantor or seller to add warranties. In such case,
It may be called a bargain and sale with covenants deed.